I declare open this hearing of the Senate Economics Legislation Committee into Scams Prevention Framework Bill. I begin by acknowledging the traditional custodians of the land on which we meet and pay my respects to their elders past and present. I extend that respect to Aboriginal and Torres Strait Islander peoples here today. The committee will be conducting today's hearing via video conference and in person. These are public proceedings being video streamed live via the Parliament's website, and a Hansard transcript is being made. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. Witnesses also have a right to request to be heard in camera. If a witness objects to answering a question, they should state the ground upon which the objection is made, and the committee will determine whether it will insist on an answer having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request the answer be given in camera. I remind committee members and witnesses who are appearing via video conference and who are not speaking to please mute your microphones. I now welcome representatives from the Australian Banking Association. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. Ms. Bly, for the Hansard record, would you please state your full name and the capacity in which you appear today?
Thank you, Senator. Anna Bly, CEO of the Australian Banking Association. I'm joined by my colleague, Chris Taylor, who is Chief of Policy at the Australian Banking Association.
Thank you. Welcome to you both. Do you have an opening statement that you'd like to give?
Yes, thank you. Can I thank you as Chair and the committee for the opportunity to appear before you today? As you know, every day countless Australians fall victim to scams. These are cruel acts carried out by international criminal gangs that are targeting our families, our communities and our friends. While every dollar that is lost is a dollar too much, the good news is Australia has taken a big step forward in better shielding the country from scammers. Sector-specific initiatives have also been very crucial in bolstering our scam defences. Banks are ramping up protections through our industry's Scam Safe Accord, which is seeing the rollout of a new confirmation of payee system, a major expansion of better intelligence sharing between banks and other sectors, the use of biometric checks for new account openings, and more payment delays and warnings. The blocking of suspect payments to crypto exchanges has also made it harder for criminals to move stolen money. Similarly, telcos have introduced measures that are blocking millions of scam phone calls and texts, and the rollout of the SMS registry will be an important next step. The federal government's efforts to coordinate industry stakeholders through the National Anti-Scam Centre in one united effort has also been a very critical step forward. As a result of these actions and others, Australia is now one of the few countries in the world that is seeing scam losses decline. Losses reported by the public to the government's Scam Watch program decreased by 41% in the 2024 financial year. This is consistent with a recent report from BDO that showed scam losses in Australia fell by 40% in the 2024 year. The BDO report, Senator, is attached to the Westpac submission to your committee. By comparison, scam losses in the UK, the USA and Canada increased in the same time period. Furthermore, the BDO report also found that in the UK, per capita scam losses are almost double those here in Australia. Our world-first approach recognises that the best way to protect Australians from scammers is by stopping them from being exposed to the scam in the first place. But there is still much more work to be done. If we are to truly make Australia a hard target for scams, enshrining in law clear obligations on all parts of the scam ecosystem is essential. That means holding Australia's banks, telcos, and the digital platforms that operate here to account for the actions that they take to protect customers. It's why, with certain key amendments, the ABA supports passage of the Scam Prevention Framework Bill. The key amendments that are sought by banks are outlined in full detail in our submission. But to summarise, we would be seeking amendments to the bill that firstly clarify obligations to eliminate conflicting and uncertain obligations between the scam principles in the bill and the sector codes that the bill provides for to ensure clear guidance for compliance and effective action. Secondly, amendments to refine the information sharing requirements to ensure that actionable, intelligent obligations are targeted, practical and effective in combating scams. And finally, ensuring harmony with other obligations to ensure that obligations in the current anti-money laundering laws and the Spam Act do not impede collective scam prevention efforts. The ABA and our members remain committed to working with the Australian Parliament and the government and other industry stakeholders to drive down scam losses and better protect Australians. I'm very happy to take any questions you have on specific aspects of the bill.
Thank you very much, Ms. Bligh. I will ask a few questions and then I'll share the call with my colleagues on the committee. I noted in your opening statement that you noted that scam losses have been reduced for the first time in many years, which is very pleasing to see. We do know, though, that these scam efforts are sophisticated and industrial scale schemes, and so that we need an effective scam prevention framework. And this will be the first such framework of its kind in this country. The government's taken an economy-wide approach quite deliberately in this framework, including the banks and holding banks to account for how they prevent and address scams, but also looking beyond the banks to telcos and digital platforms as well in the first instance. Why is it important, in your view, for scam prevention to occur across multiple sectors, not just one sector?
Thank you, Senator. Australia has been operating on this ecosystem approach really since the establishment of the National Anti-Scam Centre. And the approach starts with the principle that if you want to stop scams, you need to start with where the scam starts. Overwhelmingly, scams come to customers through their telephone, through their social media platforms, through emails. Scams do not come to customers through their bank account or their banking app. So you need to start with where the scam starts. We believe the best way to protect Australians is to stop the scam from getting to them in the first place. By the time a customer is directing their bank to transfer money to another account, the scam has already happened. The person has already been tricked and they are about to send their money to a fraudulent investment scheme or a fraudulent romance scam. So I think one of the reasons we've seen the reduction is the incredible power of bringing together all parts of the scam chain, which happens through the National Anti-Scam Centre. It's also meant that the power of bringing all of the players together means that you're much more likely to strengthen the net that is around the customer, the protective net. Scammers rely on systems being not being coordinated. They find their way in through gaps in systems. And so everything we can do to bring those systems together is another step forward. So, we've already seen just the mere fact of people sitting around that table and getting to know each other better. They're suddenly seeing ways that, if you do that, we could do this, and that might make this better. And I think that's been a very powerful process. But I do think, as you outlined, it is important to put that process into a regulatory framework so that not only do the companies involved in that process, along with the law enforcement agencies, have absolute clarity about what their obligations are, it's important that customers have an understanding of, when is the company liable? When is, what is their obligations as a customer? So giving that sort of certainty, I think, is also very important.
Okay, thank you. You've mentioned the National Anti-Scam Centre there, and you've noted that entities to be regulated under this bill, are already doing some work, but regulation is required. It's been really pleasing to see the National Anti-Scam Centre set up and some good results there. Noting that you have some comments on aspects of the bill, you have some recommendations there. Do you overall support the Parliament passing this scam prevention framework, passing the bill?
We certainly support the passage of the bill with the amendments as I've outlined. We think that there needs to be a lot more clarification between what may end up as conflicting obligations between the principles as currently outlined in the bill and what will ultimately end up, for example, in industry codes. The best way to ensure compliance and impact from legislation is to make sure that obligations are absolutely crystal clear, that there's not overlapping obligations. And I think these are very simple amendments, and we would encourage the committee to look at what we proposed in our submission in that regard in a lot more detail. I think they will make a bigger impact on what it is that the bill is seeking to achieve. So I would encourage the committee to consider those amendments.
Thank you. There's going to be further consultation and design of the sector-specific codes for banking, telecommunications, and the digital platforms. Are you intending to participate in those consultations? Of course you are. What are you looking for in those consultations, and how would you characterise the level of consultation towards getting the bill into its form today in the Parliament?
Thank you. Yes, Chair, we will certainly be participating in any public consultations undertaken by the government or by relevant agencies such as the Australian Financial Complaints Authority. There are aspects of this bill that will require, I think, ministers' rules to be put in place, codes to be developed. The Australian banks are not sitting around waiting for these codes. They have imposed upon themselves a series of obligations that we released in November 2023, the Australian Scam Safe Accord. As I said, we're not sitting around waiting for a code. We've put in place a range of actions that are required, not just the ABA, but also COBA, the Community-Owned Banking Association, have put in place a series of actions that will see, for example, more friction and delays in payments, better, faster, intelligent sharing, and a new $100 million investment in a confirmation of payee scheme. These are all ways of keeping customers safe. They've been signed up for not only by members of the Australian Banking Association, but also every building society and credit union through COBA. And what that means is it doesn't matter if you choose to bank with the smallest financial institution in Australia or the largest, you should have the same protections when you are transferring money, and the same obligations will be resting on the shoulders of your bank regardless of who they are. And we think that's one of the really important things, that consistency. It shouldn't matter what telco you use or what social media platform you're on, or who you bank with. Those are choices that Australian consumers should be allowed to make with the full confidence that those companies will be under certain obligations to do everything reasonable in their power to stop scammers from getting to those customers.
And just finally, from me, I mean, the bill sets up that framework as you've just described. It also creates avenues for redress when consumers are scammed because regulated entities have not followed their obligations in those instances where that's occurred. Do you agree that having access to redress for consumers if they are let down is an important aspect of the framework?
I think this is a very important aspect of the framework. And what is important about it is that it recognises that every player in the framework has obligations. The bill is very much focused on the obligations on companies and sectors to do everything in their power in the first instance to prevent the scam in the first place. The best outcome for the customer is that they never see the dodgy investment ad, or that they never get a phone call from a dodgy romance scam, and they never get scammed in the first place. But it does, I think, importantly, make sure that where any of those processes are not complied with or fail, then those companies that are responsible for that can be liable for redress. I know that there's lots of thinking about this whole issue of reimbursement. I think what's really important from our perspective is that that the system should incentivise people, or should incentivise companies to continue to invest in prevention. The bill has very serious penalties, civil penalties that can be imposed on companies that fail, and just as importantly, a regime that will allow those customers who have lost money because of a failure to comply by any of the companies involved some redress and compensation.
Thank you. I'll just now see whether any of my colleagues online have any questions. I'll just give it a moment to see whether they do.
Hi, Chair. I do have some questions.
Yeah, Deputy Chair.
Thanks very much for being there. So just so I understand, so you basically take the view that banks are an important part of the overall ecosystem, but once someone is already transferring their money to a scammer, then that's already led to the loss. You're in a limited position to improve the position.
That's correct, Senator. Bank fraud teams will tell you that on many occasions they do stop the transfer, or they do look. The transfer looks suspicious, so they freeze the payment and contact the customer. But if the customer insists on making the payment, and it might be surprising to many people, but banks have numerous examples of where they've told a customer that this is a scam, that this account looks suspicious, that in their view they shouldn't transfer the funds. Customers insist. Banks really have no legal grounds on which they can refuse to transfer. The money belongs to the customer, and if the customer insists against all advice on transferring the funds, there really is no grounds on which a bank can refuse to do that. Now, banks do exercise a bit of flexibility in there, as I said, by freezing a payment, trying to talk to the customer, and they do convince many customers not to make that payment or not to let it go through. The one area where they have exercised this flexibility is in relation to transfers to what they deem to be high-risk crypto platforms. That has been a really big drop in scams related to those crypto platforms, investment scams, and that's where the most money is lost. And that's dropped somewhere around 60%, those investment scams using crypto platforms. So that's why banks say, let's make sure that the customer never sees the scam in the first place. That's the best way of protecting them.
Okay, so what is the exact amendment you are seeking then?
We are looking, in fact, I might ask Mr. Taylor to go through in more detail. They're outlined in a lot more detail in our submission, but Christy, will take us through it?
Sure. The first one, Senator, in relation to the obligations, the legislation sets out certain principles around prevention and detection. From that, sector-specific codes are developed to set out really clearly for each sector what are appropriate things for them to do and where they should be investing time, money and energy into those measures. On that first piece, what we're suggesting is where a code is developed in a manner consistent with those principles and sets out what the obligations are. You don't need a regime where you've got two separate standards that you're being held to, one which is a general principle and the other which is the code. If you comply with the code, you should, by outworking, have complied with the principle as well. The second relates to sharing of so-called actionable scam intel. The banking sector has been working on sharing scam intelligence for some time through the Australian Financial Crime Exchange. It's a really powerful way to ensure that the whole sector benefits from particular insights or information about a scam.
Yeah.
The bill seeks to replicate something similar to that, where it's requiring scam intelligence to be provided to the regulator, for example, where we think there probably just needs to be a bit of fine-tuning. At the moment, all information needs to be provided to the regulator, and that could be billions of reports a year without necessarily providing an actionable side to it. So we suggested some more flexibility for the minister to prescribe what that intelligence is, so we don't end up with a very, very costly regime that is not actually as impactful as it can be, and focus instead on genuinely actionable intelligence.
Okay. And how do you think AFCA will go in this role of being the grandmaster here?
Well, I think it's fair to say, Senator, that AFCA is now, I think it's about 6 or 7 years down the track. It is still quite a young organisation, but I think to give them credit, they have developed a great deal of expertise. This will require a different sort of expertise, over time, because scams are increasingly, highly sophisticated technologically. But in terms of resolving disputes, managing, fair outcomes for customers and for the various companies that that are members of AFCA, from time to time, everybody wishes there was a different outcome. But overall, I think they are an organisation that is very well placed to put in place a new division, if you like, that focuses on this. And it's look, the other thing I would say is it's an organisation that's in existence. It's got a funding base from the industry. It will, rather than setting up some whole new government agency, this one's here. It's got capability. It will have to learn more about this area over time, particularly from other sectors like telcos and platforms. But it's there. It's ready to go. And the faster we can get this in place, the better it will be for all Australians.
Okay. And then what about the regulation impact statement? I think that might suggest that only 1.1 new FTEs will be required to quite uplift anti-scam activity and governance arrangements. Does that sound right to you, about one person per bank?
Look, I'm not sure what the basis of that assumption is. What I can tell you is that every bank has huge financial fraud teams. I think at least one of our major banks I visited recently has 500 people working on this.
Yeah.
So these are things that are already well advanced.
You're already doing that. I guess the question is really, is the regulation impact statement accurate in asserting that it would be driving, these reforms would only drive the employment of one person per bank?
Look, you can't get any guarantees on this. But remember, these complaints are already coming to banks. They are already before AFCA. These are already experiences that customers are having. What this regime does is give AFCA the ability to look at, well, where did this scam start? And how did it get to the customer? And what liability should those companies have to make their protections and their prevention efforts stronger and better? So from banks' point of view, as I said, the complaints teams in the banks are already dealing with customers. They're already dealing with the Financial Crimes Exchange. They're already doing a lot of this work. This will put a legal obligation on them to maintain that effort. I don't know if 1.1 is the exact number, but I don't see that banks would expect to see a significant uplift in staffing because, as I said, these complaints are already coming. They will expect to see an uplift in AFCA staffing, and banks will have to make their financial contributions to the cost of that.
Of course. Thank you very much.
Thank you very much, Deputy Chair. And that concludes the questions that the committee has for the ABA. The committee has agreed that responses to questions or notice should be provided by close of business 31 January. Thank you for being here to answer our questions, and you go with our thanks.
Thank you, sir.
Thank you very much to the committee.
I now welcome representatives from the Communications Alliance. Hopefully you're there to come online a little bit early. Looks like you are. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, would you please state your full names and the capacity in which you appear today?
Thank you, Chair. I'm Luke Coleman, the CEO of Communications Alliance.
I'm Christiana Gillespie-Jones, the Deputy CEO of Communications Alliance.
Thank you both for being there. Mr. Coleman, did you have a brief opening statement that you'd like to give? And if so, go ahead.
I do. Thank you, Chair. So Communications Alliance is the peak body of the telecommunications sector. We represent close to 130 members. And today we speak on behalf of our telco members and not digital platform members, which are represented by other bodies. The telco industry has a real track record in proactively addressing scams. Since 2020, our enforceable industry code has seen more than 2 billion scam calls and 700 million scam texts blocked. Combating scams necessitates a cohesive cross-industry approach, and we must be united in our pursuit of this common goal. That's why we support an overarching scams prevention framework and a cross-sector approach to scams. We see three key opportunities to address issues with the proposed legislation, which we think could be achieved via some minor amendments. First, the proposed framework has multiple avenues for liability, with multiple regulators and overlapping responsibilities. Each regulated sector should be accountable under one sector code, enforceable by one sector regulator. Telcos can't invest with certainty in the technology platforms and the compliance systems needed if they can't be sure that their adherence to the sector code is sufficient to protect them from liability. The current code establishes a quadruple jeopardy, where a telco would be liable across, first, their sector regulator, responsible for the sector code. Second, the general regulator, being the ACCC, with overall responsibility for the framework. Third, the external dispute resolution body with powers to determine compensation. And fourth, potential civil action, which could be brought by consumers or regulators on behalf of consumers, including potential claims. That a telco's compliance with the code, that it has met its obligations under the legislation. Sector codes are not voluntary. They are regulated and they are enforced with potential fines for non-compliance. Second, each industry in the framework has a different role to play in responding to scams. So it makes sense for the detail of each sector's responsibilities to go into that sector's code, rather than broad obligations in the primary legislation. The legislation should provide the necessary guidance as to what should be in those sector codes. Those sector codes can then focus on the specific circumstances, technical capabilities, and legal requirements of the regulated entities, while also allowing for greater flexibility as technology and scam behaviour evolves. There's a good recent example with the reforms to the Security of Critical Infrastructure Act. After feedback, a great deal of detail was taken out of that legislation when it was in draft form, and it was delegated to sector rules, which were then co-designed with the Department of Home Affairs and are enforceable. The scams prevention framework should follow that example. The third and final thing I would raise is that the framework and subordinate regulation, as well as the definition of actionable scams intelligence, should focus on the establishment of systems and compliance with processes, as opposed to the prevention of individual scams. Now, telcos are not legally permitted to scan individual communications, with very limited exceptions. It's prohibited under the Telecommunications Act and the Telecommunications Access and Interception Act. and it should remain so for the integrity of telecommunications networks. While telcos have different technical tools and approaches, by and large, the identification of potential scams occurs on the basis of patterns, volumetrics, and campaign indicators. Industry is concerned that the uncertainty created by certain aspects of the legislation, combined with its potential application to individual scams, will lead to highly risk-averse behaviour, including potential overblocking of legitimate messages, which could be coming from MyGov, schools, small businesses, doctors, one-time passcodes, and more. There is a genuine risk of the current framework resulting in the blocking of legitimate traffic. So telcos are caught between their legal requirements to facilitate legitimate communications and these new requirements to block scams, while facing very strict limits on their ability to scan the communications that they may be required to disrupt. Finally, I'd just highlight that within the sector, there are different roles for different parts of the supply chain. Scam traffic from an originating carrier often passes through a number of carriage service providers before being delivered by the terminating carrier. Providers throughout the supply chain have no way of knowing if that traffic could be a scam. Either amendments to the legislation or alternatively to be detailed in the designation instrument should seek to clarify the roles and responsibilities of each player in that supply chain to avoid imposing liability on operators which could not have visibility of scam traffic. Beyond this legislation, I'd like to just quickly highlight that telcos are working directly with law enforcement and taking a range of other actions to prevent scams, including some of the work that the Australian Banking Association had mentioned previously, working collaboratively with banks. Industry strongly supports the establishment of a mandatory SMS sender ID register, which will minimise the chance of scams appearing from legitimate senders. Industry is also working with the Australian Communications and Media Authority on changes to numbering arrangements, which are also designed to reduce scam traffic. Our members participate in other industry and government-led initiatives, such as the National Anti-Scam Centre, the Australian Financial Crimes Exchange, including the Anti-Scam Intelligence Loop, and through the Security and Fraud Alliance Forum. So thank you, and we welcome the committee's questions.
Thank you very much. We know that Australians are losing almost $3 billion annually to scams. It's really pleasing that that amount is reducing for the first time, including through the work that industry is doing, the National Anti-Scam Centre, the work of ASIC, amongst other things. The nature of scams, of course, is that people often feel that it's something that they experience personally and that they can experience an incredible amount of shame and distress alongside the financial losses. But we all know, of course, that these are sophisticated industrial scale schemes, often involving global criminal networks. So there's a need to act further to reduce scam losses. Is the Communications Alliance broadly supportive of introducing an overarching prevention framework to prevent losses? And are you supportive of that being a sector-wide, ecosystem-wide framework?
Thank you, Chair. Yes, we are supportive of an economy-wide framework that captures multiple sectors. I would point out that the telecommunications sector has already been regulated when it comes to our adherence to an industry scams code since 2020. That code, it's seen more than 2 billion scam calls blocked, 700 million messages blocked to date. We are already regulated, unlike some other sectors. So we do welcome other sectors being brought into that framework. What we have pointed out in our submission is that when it comes to the issue of liability for scams, a couple of important points. First of all, we hope that there will be a single sector code, so similar to the code which we already operate, but would be established newly under this new legislation, in which that one code would be enforced by one regulator, rather than having multiple regulators enforcing different parts of the framework, which we think will make it very difficult for telcos to be able to invest with certainty in the technology and the compliance systems needed to uphold that industry code. Sorry, Chair.
I'll just stop you there to make sure the committee understands your evidence there and let you continue. But under the overarching framework that's been developed, there is a role for the ACCC as an overarching regulator. Are you talking about the telecommunications code, which would be developed, and ACMA would be the regulator for that? Are you saying that you don't wish for there to be a specific telecommunications code that is overseen by your regulator?
Sorry, it's actually the opposite. To clarify that previous statement, we think that there should be a single sector code which industry is held to. In this case, it would be put in place by ACMA for the telco industry. The issue that we are pointing out is that there is then the second regulator being the ACCC with the overarching framework. We struggle to see a circumstance where a participant could be in compliance with the sector-based code, but could then subsequently fall foul of the broader framework. And what we are putting forward is that if you are in compliance with your sector code, which is regulated by your sector's regulator, that should mean that you are in compliance with the legislation. If you're in compliance with the code, you're in compliance with the legislation. It creates a great deal of uncertainty if you could be in compliance with your sector code, but then be found to not be in compliance with the broader scams prevention framework. And it would make it very difficult for a telco to be investing in the technology platforms needed, as well as the compliance systems needed, if they could meet the terms of their industry code, but then still fail to meet the terms of the broader framework.
Okay, I understand that. And presumably you put that view in the consultation around the bill, and some changes have been made in response to consultation around the bill. Are there specific changes that the Communications Alliance is pleased to see incorporated in the bill from the consultation process?
Yes, thank you, Chair. I should have pointed out in my opening statement that the bill which has been put before Parliament is a great improvement over the original draft bill, and that one of the main things that the bill before Parliament did over the previous draft was it delegated a lot of the detail from the legislation itself into the sector-based codes. However, I would point out we think it can still go further. There is still more detail in the bill that is currently before Parliament, which we think would be better off in those individual sector codes. There are different rules, different responsibilities and roles for banks, telcos and digital platforms, that it makes a lot of sense to have those individual codes address those specific needs. And I might turn now to my colleague, Christiana, who can put a bit more detail around that point.
Thank you, Luke. Thank you, Chair. With respect to the potential to fall foul of the larger frameworks whilst being in compliance with the sector-specific code, there is the entire framework operates under the assumption that an entity takes reasonable steps to implement specific requirements under the framework. And we think that it would be useful to make clear that the reasonable step that an entity needs to take and make this an exhaustive requirements rather than an inclusive as it's currently drafted would be to say the compliance with your specific sector code is the reasonable step that an entity has taken and thereby then would be deemed in compliance with the framework. Currently, the fact whether or not an entity has complied with a sector code is one of the factors that is only relevant in consideration of whether reasonable steps has been taken. And that in and of itself does not give an entity sufficient certainty, and we don't really understand the need for this. If the intention is to have a framework applicable to other sectors that may not be, like our sector, already be covered by legislation and regulation, then we think that problem can be addressed differently by, for example, having the sector, the overarching framework applied until such a code comes into effect. That would actually, I think, incentivize any sector who doesn't have yet a code to get going and develop such a code to avail themselves of the regulatory certainty that would come with compliance with the sector code.
I'll ask, I'll just indicate that I'll ask Treasury for a response later in the day on the question you've raised on the interaction of the ACCC enforcing the principle-based obligations and being the overarching regulator, including for reporting purposes to make sure that there is joint information across the different industry codes, and ask them about the interaction with the individual regulators in the individual industry codes. You raised an issue in your submission and in your opening statement about consumer redress and the number of avenues for consumers. I think I should just clarify, obviously, clarify your position on this. Obviously, there's been tremendous consumer harm over the years. We've all met with people, we've all heard terrible stories. We know what the overarching statistics are, albeit that scam losses are reducing. It's a huge issue. The bill sets up an obligation to have internal dispute resolution. I know that you'll say that you already have that. We have digital codes also being put in place as well. And the bill sets up the first external dispute resolution, and the Minister will designate AFCA to do that. Are you supportive of there being that EDR so that if there are failings in the implementations by regulated entities of the codes, that consumers have a place to get that really important redress?
Thank you, Chair. I would say yes, with a couple of conditions attached, that we have not sought to oppose consumer redress. What we have sought to clarify in our submission is, first and foremost, if a telco is in adherence to their industry code, then that should mean they are in compliance with the legislation and therefore should not be subject to liability. Our primary concern here is that even if a telco has upheld everything in their sector code, which is regulated by the ACMA, that they could still potentially be liable through the external dispute resolution body. That would create a vast amount of uncertainty for a telco if they were meeting all of their obligations under a code, yet could still potentially be held liable as one of numerous liabilities under the current legislation. The second thing that we seek to point out in our submission is that when it comes to the role of the EDR scheme in apportioning liability, that there should be a waterfall of liability. And this is a model which is based on the Singaporean Monetary Authority and their approach to scams, where ultimately it is only banks which have the capability to block a fraudulent or scam transaction occurring. That ultimately the banks are the custodians of their customers' money. Telcos cannot block a bank transaction from occurring, only banks can. And so ultimately our view is that the banks are at the top of the waterfall, and therefore, first and foremost, compensation should be coming from the banks, because that's solely where the ability to transfer funds to scammers lies. But I would add to that, we've also stated in our submission that if a telco is not in compliance with its sector code, then yes, they should be open to consumer redress through the EDR body, but only in the cases where they are not in compliance with their code. Christiana, did you want to add any more detail to what we put forward in our submission?
Oh, that's okay. I'll just need to share the call, and you'll have the opportunity in answer to other senators. So I will just check if the Deputy Chair has questions, and if not, I'll go to you, Senator Pocock in Canberra, if you have questions.
Thank you for
Senator Pocock.
Thank you, Chair. Thank you for your time today. I note Telstra was initially foreshadowed to appear today. I'm interested why they aren't.
Without wanting to speak on Telstra's behalf, Communications Alliance represents 130 members from across the industry. A number of our members have made individual submissions to this, and so Comms Alliance is speaking on behalf of the broader industry.
Mm-hmm. And I think everyone is agreed about the need for a cross-sector approach and a focus on prevention. But I wanted to ask about the reimbursement of scam victims, which you were just talking about, because it seems like the biggest weakness of this proposed legislation. And putting your quadruple liability concerns to one side for the moment, do you think that in principle any regulated entity who has liability for a scam should also be liable for paying compensation?
Should any entity that is liable for a scam be liable for compensation? What we have put forward is that if you are in compliance with your industry code, then you have met all of your regulatory obligations to stop scams, knowing that each of the regulated sectors under the framework, being banks, telcos and digital platforms, all have different responsibilities. Telcos can calls and texts, and we are held to account by the regulator already for blocking calls and texts. Similarly, banks are the only part of the supply chain which can block a bank transaction, and digital platforms are the only ones that can prevent, a fraudulent or a scammer ad being posted on a social media platform. So I would say the principle we should seek to uphold here is that each sector should be held to account for their sector code. And if they are not in adherence with their sector code, then it should open up the door for them to be potentially held liable for consumer redress.
Okay. I mean, this seems, surely it's a bit more clear cut. If you're not holding up the code, you should be reimbursing. Is that not how you see it?
It will be dependent on the circumstances of the scam, and this is something that would only be decided in the enactment of the framework and subordinate legislation of how much liability would be potentially apportioned to a bank or to a telco or to a digital platform, depending on the specific circumstances of the scam. At this point, I will turn to Christiana just to add any more detail that you might want to bring up here.
Yeah. And I guess... Go for it.
You go ahead.
Well, thanks. I mean, that's useful, but I guess from what I'm hearing, it's sort of reinforcing the point that's been made to be by people I represent here in the ACT who've been scammed, or consumer groups who are saying that without a reimbursement model, you get caught in this endless cycle as someone who's been scammed of going to the telco, going to the bank, and there's this huge power asymmetry where you've got all the information and you basically say, well, no, we complied with the code, not our problem. What do you think about the proposal for one entity to reimburse the scam victim and then other regulated entities apportion liability amongst themselves if they're not in compliance with the code? So say a bank in the first instance may reimburse, and then if you haven't done your job, you would be liable. If you have, it may be the social media company.
I think that's not too far from what we've suggested to say. So if the fraud has or the scam has actually occurred and has materialized, which is means that a financial institution has in one way or another been involved and the transaction has occurred, and the financial institution has not been in compliance with the obligation, then that's exactly what we deem is the easiest for the customer to go there, because otherwise the loss wouldn't have occurred. If the bank has adhered to all its obligation, but we find that further down the telcos or the digital platform sector or other sectors have not adhered to their obligations, then by all means we see that an apportioning of guilt or of compensation needs to occur amongst those sectors.
So this would address that exact issue that you've just raised of people trying to pass the buck between sectors and an information asymmetry, that the external dispute resolution body, which would have the information available to it on the scam, would see which sectors have upheld their codes, which sectors have not, and therefore would be in a position to be able to apportion liability.
And thank you. So just so I'm understanding it correctly, in your view, it should be up to the scam victim to then work through, say, AFCA to seek reimbursement, rather than having sort of an automatic reimbursement, unless there's some sort of negligence, and then between the different players, you work out the apportionment of who pays what.
Certainly, there is both the opportunity for an internal dispute resolution where the parties would come to an agreement between themselves before it goes to an EDR and decide to reimburse the consumer. But then ultimately, there is the role of AFCA as the EDR in the legislation to make that decision on the consumer's behalf. But certainly we're not opposed to an internal dispute resolution scheme between digital platforms, banks and telcos, where in the case that somebody has been scammed, that they would be able to share information about that particular scam and each party's role in it, and potentially offer compensation to that consumer. But there is always the foundation of having the EDR body there that can ultimately make that decision.
Thank you. Thank you very much. Thank you, Chair.
Thank you, Senator Pocock. I'm just checking whether anybody else was seeking the call, and I don't think
I am.
You are, Senator Smith.
Yep, I am. Thank you very much. Just on this point, because I think it's an important one, just on the point that you were labouring over with Senator Pocock, on notice, can you provide to the committee why it is that the consumer redress mechanism that's in Division 6 is not a simple, faster and effective form of redress?
So you would like us to, on notice, clarify?
Just on notice, yep. Just for
current drafting is not, in our view, the best workable solution.
That's right. So what I would like, because of my limited time, what I'd like you to do is on notice, just elaborate on that point a little bit further. What are the risks if this bill is passed in its current form and not amended in a way that you've proposed?
I think that the main risk, Senator, that we would point out is the multiple avenues for liability. That is a primary call out from us, that it will not allow telecommunications operators to invest with certainty in the technology platforms and compliance systems needed if they could be found in adherence with their sector code, but then not in compliance with the framework overall.
And with respect to the consumers, and I'm not sure, I think that's where you were targeting, we don't think that the current bill provides sufficient detail as to how such an apportioning or even the mechanisms of that redress would occur. And I think a great more detail would be required, either in the SPF rules that are foreshadowed, and that might be the most useful place to put those put that detail, or in the code. At the moment, we can only assume that that detail to the apportioning of redress would sit with AFCA, but the bill itself does not provide sufficient detail.
When these concerns have been raised with the Treasury, what has been their response to the telecommunications industry?
I think that the changes we saw from the initial draft of the legislation to the draft which was introduced in Parliament were very positive and showed the Treasury was listening to our concerns. We would simply seek to highlight that we can go further still by taking more of the specific detail out of the primary legislation and delegating it into sector-specific codes. That would be a key call out for us, but Treasury has been engaged on that. I think they've responded well to that in the most recent, well, I shouldn't say most recent draft, in the bill which was introduced to Parliament, but in its current form, we're concerned that it doesn't go far enough to delegate into sector codes what is currently in primary legislation.
If the bill is not improved in the way that the telecommunications sector suggests, does that mean that Australians consumers are getting second-rate protections to scamming?
We think that it will not provide sufficient certainty for each of the three sectors to be able to combat scammers as effectively as possible. I think for all of the three sectors that are involved in this framework, they want to be able to provide the best protections for consumers. They want to be able to provide an environment where they can invest with certainty in new technologies. And to be clear, Senator, telcos are already investing very heavily in anti-scam technology and have been for a number of years under the current code, I should say. So the improvements that we have suggested to the bill, which we think would be some relatively minor amendments to the current legislation, we think would certainly provide an enhanced environment for consumer protections.
If I may add, we also see the risk that because of the lack of certainty and the liabilities associated with it, that telcos will resort to what we would call over-blocking, to err on the side of caution and to block, because telcos block in a way on chances of probability and the likelihood. They look at patterns and specific technical identifiers. And those are present in a vast array of different types of communication, including from government, as Luke had mentioned those in the beginning, where they're all present. If no greater certainty is created, there is a greater risk of blocking what may or may not be a legitimate communication.
How does the issue of quadruple jeopardy that you talk about in your submission, how is that best mitigated against?
Thank you, Senator. I think for the exact reason that Christiana just described, telcos under the current framework, where there are multiple avenues of liability, where they could be in adherence to their code but still fall foul of the framework, could still be liable for compensation, could still be liable for civil action. That is the thing which is most likely going to lead to overblocking of legitimate communications. Given that a telco can't eavesdrop on your phone call, and nor should they. They can't read in individual text messages, and nor should they. They detect patterns of traffic, and that is the basis by which they attempt to see what is likely to be a scam or not. That by removing that multiple avenues of liability and instead having a very clear one sector code that is enforced by one sector regulator gives a great amount of certainty. And I think that that higher certainty will lead to a greater blocking of what are actual scams and significantly reduce the blocking of potentially legitimate traffic, which is targeted because it looks like a scam. And we should remember, scams that are carried by telcos, they are made to look like legitimate traffic. That is why they are hard to block, because scammers are absolutely astute at targeting something that looks like a legitimate MyGov message, like a legitimate communication from a charity or from the government. And so if a telco has any concern about that traffic being a scam, and they think, well, not only am I liable to my code, I might also fall foul of the framework or be liable for civil action, there's going to be a bias towards blocking that traffic, even if it is legitimate. That is a very dangerous position for this legislation to put the sector into. And I don't think it's ultimately good for Australians. to be at risk of missing out on legitimate traffic.
We're at time. We're at
so
time.
just one last question, if I may, Senator Walsh. Thank you very much. The risk for the consumer in the way that the law is, the risk for the consumer is that the way that the current legislation is framed could deny legitimate messages or traffic being passed to Australian consumers.
Correct.
Thank you.
Thank you, Senator.
But just finally, your evidence is that you believe that you can sort these issues out in the development of the industry code with ACMA, that you can work out a code that stops scams being conveyed to people by their carriage service, and that you can do that in a way that doesn't stop legitimate traffic if you are tasked to work on that with ACMA.
It's, if I may, very black and white. But yes, we think that's the best way to do it. We can minimise the false positives, and we can maximise the amount of traffic that we legitimately block.
Yeah. Okay, and just noting again that that is the structure of the bill, that you would be working as an industry on this with ACMA, but I understand your concerns about the role of the ACCC, which I'll ask Treasury about. Thank you very much for your appearance today. The committee's agreed that responses to questions or notice should be provided by COB 31 January. We ask that you now disconnect from the video conference and you go with our thanks for your evidence today. Thank you. I now welcome the Digital Industry Group. DIGI, I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full names and the capacity in which you appear today?
Thank you, Senator Walsh. I'm Sunita Bose. I'm the Managing Director of the Digital Industry Group, or DIGI for short.
Thank you and welcome, Ms Bose. Do you have a brief opening statement that you'd like to give?
I do, Senator Walsh. I'm coming to you from Gadigal land and would like to pay my respects to elders past and present and acknowledge the lands on which we meet. I'm very grateful for the committee's time today, given the very short notice for this hearing, and also I'm grateful for the opportunity to appear. By way of explanation about DIGI, we're a non-profit industry association that advocates for the digital industry. We bring together major tech companies with the government to realise our vision for a thriving Australian digital economy, where online safety and privacy are protected. Combating scams has been a key focus of DIGI through our long-standing involvement in the government's National Anti-Scam Centre and our development of the digital industry's voluntary code, the Australian Online Scams Code. These initiatives embody our commitment to reducing online scams and safeguarding Australians. With that vision, I wish to underscore 3 key points at the outset. The first, DIGI supports strong scams legislation with an ecosystem approach that bolsters a wide range of industry scam defences. While we support this legislation's overall intent, certain critical amendments are necessary to ensure that it is both effective and clear. The second point is that DIGI supports mandatory industry codes with penalties for non-compliance. Digital platforms should be held to account under a clear, robust set of legal obligations. Given delays with this particular legislation, DIGI developed an interim blueprint for anti-scam measures for the diverse digital industry by way of the Australian Online Scams Code. The third point is that we support a strong National Anti-Scam Centre. Regulators must be set up for success to protect Australians from scams, and we see some important improvements to the bill to ensure that. With those points in mind, I asked the committee to make 3 high-level recommendations, and these recommendations are detailed within our submission. The first is to streamline obligations. We need one clear set of obligations that are targeted to each sector, including digital platforms, that outline the specific reasonable steps they must take. Instead, we have a generic set of obligations that are an awkward fit for the current and future sectors, and they're not clear for neither industry nor consumers to understand. The second high-level recommendation is that we need to refine reporting. The bill has an obligation to report all potential scams to the regulator with an extraordinarily broad definition of a scam. This will inundate the regulator with more information than they can handle. Specific reporting requirements need to be developed under the industry codes to more directly benefit Australian consumers. The third point is to clarify liability. No one can confidently explain today when companies are liable for scams because those key details haven't been worked out before we're legislating. With dozens of companies involved in any one particular scam, that confusion will frustrate consumers. It will see industry focus on finger pointing, sometimes over lengthy legal battles, rather than collaborating to beat scammers at their game. Behind almost every scam today is a sophisticated operation of white-collar criminals who are creating an attack chain across different services that Australians use every day. Digital platforms stand ready to work closely with law enforcement to crack down on criminal offshore scam centres. And coupled with law enforcement efforts that stop scams at the source, this bill can really bolster scam defences across different sectors. But it needs important amendments, because ultimately crystal clear obligations for industry mean better outcomes for consumers. There are many more recommendations that we've made in our submission, and I look forward to discussing this important bill with you today.
Thank you very much, Ms. Bose, for the opening statement. First of all, it's been, really pleasing to see that scam losses from Australians have decreased for the first time in recent years, but we know that with almost $3 billion in scam losses in the country each year, and a whole lot of personal stories behind each one of those, and as you said, the really high concentration of criminal activity in this sector, that there's a real challenge here. Does DIGI acknowledge that the digital platforms have not done enough as it stands to combat scams that happen on platforms?
What we need to see from digital platforms and from every sector that's exploited by scammers is a real stepping up. And I do think this bill, with its mandatory obligations, will see industry step up and do the very best that they can. Certainly from my vantage point, working with the digital industry on voluntary initiatives such as their cooperation with the National Anti-Scam Centre and the cooperation they all undertook together to develop the Australian Online Scams Code, I am seeing a real concerted investment and focus in this area, and I think this legislation will play an important role in ensuring that investment continues.
Thank you. You said in your opening statement that you are supportive of an ecosystem-wide or economy-wide approach which this framework seeks to implement. Why do you think it's important that it is ecosystem-wide?
It's really important that it is ecosystem-wide, and I welcome the government's focus on an ecosystem approach, because every story of a scam has a complex attack chain. Scammers, in order to be successful, need to build a web across exploiting various services that Australians use every day. They start by building the financial infrastructure in which to receive funds, often through offshore bank accounts or cryptocurrency. They then build legitimacy, often sometimes by creating fake ABNs or building a fake social media profile in order to deceive consumers into their legitimacy. They then make contact, perhaps through a messaging service or through by telephone, and they engage Australians into a conversation in which to secure their personal information and their financial information. And then once they obtain that financial information, that's where they carry out theft through financial services. So when you look at any particular scam and you look at the complexity of that attack chain, I think I've stepped through about 5 different areas, and some scams will have more. There are dozens of companies that are involved in every particular scam. And what we really need to see, which I hope this bill will encourage, is a bolstering of defences across every single sector that scammers exploit.
Thank you. This is a framework bill, as we know, and it's a principles-based approach, and each sector would work with its regulator to develop codes to implement the principles and work through the details. Are you confident of the ability to work with the ACCC in the case of digital platforms to work up an effective industry-specific code?
DIGI has a long track record working with the ACCC and the national anti-scam sector, and ultimately the industry will work with whichever regulator is deemed most appropriate for this scheme. I will note, while we're on the subject of the regulator for this scheme, that it was originally floated that the Australian Communications and Media Authority, or the ACMA, be the regulator for digital platforms, and that an original proposal made sense to me, as the ACMA has a track record of working with the telecommunications industry on scams. It has a track record of working with the digital industry on the Australian Code of Practice on Mis and Disinformation, which DIGI also developed and oversees. So we consider that the Australian Communications and Media Authority does have the subject matter and sectoral expertise to be the regulator for the digital industry. Having said that, one of my broader observations with this bill is that it could better empower the ACCC with relevant powers. Here, right now in Australia, only ASIC has the ability to direct a website to take down an investment scam, but it may surprise the committee to learn that the ACCC does not have the power to go to a digital platform or to any website that may not have the policies in place that many of the mainstream digital platforms have, and compel the removal of a scam website. And we consider that this is a vital piece of the broader puzzle when it comes to ensuring that we have empowered regulators with this regime.
Just finally from me, one of the issues that is regularly raised with members of Parliament when we're hearing, the really tragic stories about people who fall victim to these industrial scale scams is the challenge of figuring out where to go when the scam pertains to a platform. For example, if a car's been advertised on a platform and it's not a real transaction and someone is scammed for that. The lack of internal dispute resolution's been raised, I'm sure, with a whole lot of members of Parliament. Can you talk to us about your position on mandatory internal dispute resolution and also, of course, the importance of external dispute resolution, in this case through AFCAR, so people have clear channels to go to if they are really unfortunately and despite best efforts scammed on a digital platform?
This is a really important question, Senator Walsh, and I'm glad you've raised it. There are a couple of different elements to step through. One thing that DIGI has done through the development of our Australian Online Scams Code is to clarify that all of the signatories to the code, which include 9 of the major technology companies, must have avenues through which scams can be reported and must have teams and technologies in which to address those scams. It also provides guidance on acceptable takedown turnaround times for scams. Certainly that's an area where we want to see the industry to continue to invest. Further, DIGI's also produced a resource on our website to make it clearer to consumers how to report scams to a range of digital platforms, because we want that information, those reporting tools to be used. In terms of the broader questions around internal dispute resolution, this is an area where we've also been working with the Department of Communications around how we clarify obligations across our sector. And so I do consider that under this bill, there will be mandatory codes in place for the digital industry and other industries, and that's a good opportunity to clarify the minimum standards that consumers should expect when reporting scams to digital platforms.
And you are supportive of external dispute resolution, including redress and reimbursement overseen by AFCA?
There are a couple of things to say on this question. Well, one of the challenges with the redress scheme that's being proposed in this scheme is that it hasn't quite been fleshed out. As I said in my opening statement, there are many unanswered questions here, and ideally we would all understand the answers to those questions before this is being legislated. If we are contemplating a liability model, it may make sense, as the previous witnesses from the Communications Alliance indicated, it may make sense at the point at which a service has breached their mandatory sector-specific obligations. But I would also agree with some of the broader points made by the Communications Alliance that some of those sectors, some of the obligations in the primary legislation are quite unclear. And because we don't yet have those obligations that are sector specific, because the mandatory codes have not yet been developed, it's hard for industry to know confidently the point at which liability would kick in. And so if industry is uncertain about this, consumers will be uncertain too. We have to remember what's being proposed here is a departure from the direction of other jurisdictions such as the UK and what's being proposed in Singapore. And it's also not what Treasury recommended to the government in documents that have been released under FOI. So my recommendation would be that we really determine what those primary obligations are for sectors so that there is greater clarity when it comes to addressing questions of redress.
Okay, it's certainly interesting evidence to get from industry groups that instead of working things through as an industry with their regulator in a further consultation, they'd like more to be specified in the bill itself. So that will be interesting to consider, because obviously it's not a choice to do nothing when there's $3 billion in losses from Australia. So either the bill is loaded up with the detail that you're seeking, or there's industry consultation with the regulator. That seems to be the situation.
May I clarify my remarks, Senator Walsh, because I think you raise a very important point around what's the right balance when it comes to information in the primary legislation as opposed to information in the secondary legislation. And I believe we find ourselves in a position right now because of the timing of this bill. This bill was released in September and it was advanced through Parliament in November. And so one of the fundamental problems that DIGI sees with the bill that others have also noted is that there are two disconnected sets of obligations. There's a generic set in the primary legislation, which we can broadly see in Division 2. And that's designed to apply to all three sectors, banking, telcos, digital platforms, but also future sectors like superannuation. And then there's going to be a specific set, which will be developed under Division 3. And these are forthcoming. They will also have strict penalties. And in short, as I said in my opening statement, I'm supportive of of the process that will unfold under Division 3. DIGI has participated in many mandatory code development processes. We work closely with the e-Safety Commissioner and with the ACMA, and there's a very collaborative process that ensures that you've got very specific, very targeted, very actionable obligations that are easy for consumers to understand if an industry has breached. So, for example, if we retain the obligations that are in Division 2, there's nothing very specific to digital platforms. There isn't, for example, any specificity around taking down scams, because these obligations have been designed to apply broadly. Because I understand, to your point, Senator Walsh, the seriousness of the problem and the government's strong desire to act, that they wish to put some obligations into the primary legislation. But my concern is that these obligations aren't as clear and targeted and effective as they can be, as opposed to the obligations that would work, where regulators would work closely with the sectors to determine obligations that apply very clearly to their specific sector.
I will ask Treasury about the relationship between the ACCC and the overarching principle-based obligations and the sector codes, as I indicated I would earlier. I'll go to you, Senator Pocock.
Thank you, Chair, and thank you for your time here this afternoon. I'm interested why none of your members are appearing before the committee and why some of your members declined to appear.
Thank you, Senator Pocock. My understanding is that there were scheduling conflicts, and today I also observed that the industries are represented by their industry associations.
Mm-hmm. Okay, thank you. Do your members accept that they should participate in reimbursing scam victims and have some liability for scams that are perpetrated on their platforms?
Senator Pocock, as I said before, I do believe redress is an important part of this equation, and we're very supportive of it being further explored. But my broader concern is that we're exploring redress without having really clear obligations for the industry. What we have to remember here is that what's being proposed in Australia is a departure from the UK scheme, as I said, and from the Singaporean model, which I believe Mr. Coleman elaborated on earlier, where it's very clear to a consumer in the first port of call they go to this industry, and the second port of call they go to that industry. Now, that is not at all to say that every industry must step up and must have really strong legal obligations, and that part of this bill is very much welcomed if we can get those obligations right. Mm-hmm. But my suggestion is that we focus on making sure those obligations are really clear so that we don't frustrate consumers in the process of trying to seek redress.
Mm-hmm. Okay. Reading through the submissions from your sector, many of them suggest that banks should be the only entities compensating consumers for scams, which to me suggests that they don't see platforms as having any responsibility to Australian consumers. And so I'm just wanting to sort of work out, are your members willing to address the financial cost of scams to Australian consumers?
Senator Pocock, in my experience, the digital industry does very much accept its responsibility for scams on their platforms. And from my vantage point, I do see a tremendous investment of enormous engineering teams, technology, tools in order to address this. And certainly the industry got together, they developed the Australian Online Scams Code, they worked proactively to put a stopgap in place while we waited for the details of this legislation. That shows a commitment to wanting to protect Australians. Now, when it comes to the question of redress, other jurisdictions have opted for a model that we consider maybe clearer for consumers and also potentially more effective. It's really important to look at the data here, and while I do have broader questions around the data, ScamWatch data does indicate that 5.8% of scams in Australia originate on an online forum that includes professional trading websites, and an unknown subset of that is social media. Now, my hypothesis is that even if this portion of the industry absolutely perfected their anti-scam game, and we want to see those continual improvements over time, scammers are sophisticated, they work in office buildings, they will find other means to make contact with Australians. By contrast, almost every scam ends with financial services. So if we want to pinpoint the part of the scam attack chain that may have the biggest ripple effect in providing redress to Australians, it may be the financial services sector, but that is not to say that the digital industry and other sectors under the Scam Prevention Bill shouldn't have strong legal obligations with tough penalties. They absolutely should.
Mm-hmm. Yeah, I mean, it surprises me that some of the big companies that you represent aren't doing more in this space. Sort of a real life example. Myself, and I've spoken to others who repeatedly get served a very compelling looking sale on on Meta for a popular outdoor brand, 80% off. There's no way to, report it. I've actually been in contact with the company. They say it's an ongoing issue where every time they get it shut down, another one pops up purporting to be this company. It just seems, with today's technology, pretty outrageous that Meta can't find a workaround. And my concern is that no one's forcing them to, so why would they? It's actually good for business because these fraudsters, these scammers, are actually paying Meta advertising revenue. So at the end of the day, they're getting money for it. And so that's why I'm so keen to get the scams legislation right, because it seems like, regardless of what Meta and others may say, at the end of the day, it comes down to dollars and making sure that they're on the hook.
Thank you, Senator Pocock, for the question. While I don't necessarily accept the premise that they are profiting from scam advertising, because my view, and you may disagree, is that the investments that I'm seeing from the sector in terms of major engineering teams, technology, tools, far outweigh any of that. But certainly I take your broader point, and I agree that what we want to see is continued improvements from the sector. It's something that we worked to codify even in the voluntary code that we put in place just as an interim measure while we waited for this bill to be legislated. Fundamentally, where we agree is that there should be mandatory obligations for digital platforms, and that there is a real opportunity for those obligations to be very specific. So, to use your example, they might look at specific situations pertaining to scam advertising. They might look to specific initiatives as to how you might prevent the same scam from reappearing. You can't get that level of specificity if you're trying to build obligations that fit across 3 different sectors: digital platforms, banks and telcos, and also the future sectors that the government wishes to bring into the scheme, such as superannuation, for example. So there's an opportunity to get the details of what needs to be done to protect Australians right through these mandatory codes.
Okay, thank you very much. I'll put a few more on notice. Thank you, Chair.
Thanks, Senator Pocock. Senator Smith.
Thank you very much, and thank you very much for your participation today. Is the government's legislation too lenient on the banks?
Senator Smith, what we've seen in this bill is a departure from the direction of travel of other jurisdictions, where they do recognise that that interventions with financial services may have the biggest consumer ripple effect. Certainly, I support the government's approach in wanting to take an ecosystem approach, but I do worry that there has been a bit of a I'll leave it at that. Thank you.
In your submission, you say, and I quote now, it says, it is evident that the government has developed a bespoke model that rejects the model that has been implemented in the United Kingdom, where a mandatory reimbursement model for banks has been introduced for consumers. While it appears that there has been intense and ongoing consultation since 2022 with the Australian Banking Association on the framework, and then you footnote that comment based on FOI documentation, and then you say the same level of consultation has not occurred with other regulated industries about the model. Why would the government engage with other regulated industries so late in the piece when, based on those FOI documents, it looks as if it's been engaged with the bank since 2022?
Thank you, Senator Smith. And first of all, I want to make the point that consultation, including industry consultation, is a good thing. For an ecosystem approach to be successfully designed and implemented, all of the regulated sectors need to be engaged in consultation so that we can really ensure that that we get the details right. I do, as I said in our submission, I do think there has been a lack of consistent industry consultation as early as occurred, as released and through those documents. And so that is one of the reasons that may contribute to why we've got a set of obligations being proposed in the primary legislation that are an awkward fit for the current and future sectors. this policy that the government announced prior to the 2022 election to have mandatory codes, I believe that was announced prior to the 2022 election, and we saw the release of the legislation in September 2024. So we all have worked very quickly to, and there, as Communications Alliance says, there has been consultation from Treasury, and we welcome that in more recent months. But that sort of concerted consultation across the different industries is what ensures that we get the details right, and we need to ensure that there's a parity there in the way that the sectors are consulted.
What are the risks to consumers if the current bill in its current form is legislated?
Senator Smith, it's an important question. The risk is confusion and frustration, because right now, as I've said, we've got a set of obligations that have been put in the codes. I understand the government wants to act and wants to act quickly and wants to put forward some strict obligations in this primary legislation. But the challenge with that is that we've got a set of obligations that are an awkward fit across the different sectors, as I've said. And so it's not then clear to consumers what specifically industry needs to do. So to dive in a bit more, the primary legislation makes repeated reference to this notion of reasonable steps. But industry couldn't tell you what reasonable steps are. They may have a different interpretation to consumers. And what I consider the best course of action right now is for reasonable steps to link directly to the obligations in the mandatory codes. They'll still be strict. They'll still have tough penalties. Companies will still need to comply. But then everyone is singing from the same song sheet, consumers and industry, and they understand exactly what an industry needs to do and exactly when they have failed.
Why is it that the reasonable steps requirement are, in your view, what is the motivation for making them vague? What's the motivation for not giving them greater clarity?
It's a good question, Senator Smith. I can't speak to the motivation, and I should acknowledge that I welcome some amendments that the government did make to clarify that reasonable steps can be stipulated in the codes, but it's not conclusive. It doesn't say that reasonable steps are the codes. So again, I cannot speculate to the government's intention, but perhaps what is trying to be achieved here is a framework that is sector agnostic, but I would argue it's not sector agnostic. It's just quite vague, and therefore the result could be quite a significant amount of frustration for consumers as they attempt to navigate this regime.
Digital platforms are agreeable to accepting liability for scam activity. That's a correct statement, isn't it?
As I've said, the details need to be worked through, and the first step is determining what those obligations are, working with the digital platforms, with the banks, with the telcos to determine specific obligations that make sense. I think Communications Alliance spoke to some of those dangers of overcorrection, and I would echo some of those concerns when it pertains to the definition of a scam, which is quite broad. Right now, the definition of a scam captures personal information when no theft is involved, which means that if I lie to you, Senator, about my name and ask you what your name is, this could technically fall under the definition of a scam, whereas I think we could both use a common sense understanding that that is not a scam. But when you couple a penalty regime that's quite strict with broad definitions, it does mean that there is lean towards overcorrection in order to avoid those penalties. So fundamentally, these are the details that we need to work through before contemplating a sort of redress scheme that's based on a failure to meet obligations.
Do you agree with the Communications Alliance's view in regards to the waterfall approach to compensation?
Singapore, I broadly speaking, yes, I think that Singapore is going in a direction where it makes it clear to consumers where to go as I've said, my worry with this regime is that it is going to lead to consumer frustration. Certainly in Singapore, from what I understand of the proposal, and I believe I have the details here before me, try to find them, but in Singapore, the government has proposed that financial institutions bear the primary responsibility for losses. And a quote I have here is, "Financial institutions stand first in line given that they hold greater responsibility as custodians of consumers' money." I will emphasise that 100% of scam cases involve a financial service. And so focusing anti-scam interventions on banks, including liability, would be a simple, easy route for consumers to understand. But I really want to emphasise that digital platforms must also be held to account through strongly built obligations. But as I said, with 5.8% of contacts coming from online forums, which does include a much wider range of websites, including professional trading websites, social media is still a quantifiably unknown subset. So while we certainly need to see improvements in this sector, I fear that that scammers will be relentless and determined in exploiting a number of different communications channels in order to make contact with victims.
Thank you.
Given that other jurisdictions are
just a final. Sorry, Senator Smith. I'm not sure whether you can hear me. Just a final question, Senator
Thank you.
Smith.
Given that other jurisdictions are, developing their own models, why is it necessary for Australia to have, in your words, a novel approach, a novel model? And why wouldn't we seek to replicate or amend for Australian circumstances international models that might already be in operation or on the existence of being implemented? Why is it necessary for Australia to have its own novel model?
It's an important question, Senator Smith, and insofar as the Australian model encourages scams prevention, I'm supportive of that. Insofar as the redress scheme contemplated, as I've said, I do worry, given the complexity of the scam attack chain and the sheer number of services that scammers exploit, that it is going to lead to a confusing consumer experience. And it's important to note, in the documents that you noted earlier, Senator Smith, Treasury did actually recommend to the government that it pursue a single sector bank-led scheme in the first instance. Treasury did note the complexity of a multi-sector scheme and that such a scheme could be considered at a later stage. So we are pursuing an untested path, and it certainly requires us to get the details right.
Thanks, Senator Smith. Just a final clarifying question. You've been asked a couple of times, Ms. Bose, whether you accept that digital platforms should be held liable if they do breach their obligations, their mandatory obligations under a scam prevention code. What is the yes or no answer to that? So should digital platforms be held liable if they breach their obligations under a scam prevention code?
Senator Walsh, the answer is potentially, because we need to ensure that those obligations are clear.
You don't accept that you should provide redress to consumers?
I accept that digital platforms have a really strong responsibility to consumers, and that is why DIGI, the organisation I run, worked very closely with the digital platforms to put something in place while we were waiting for legislation. I accept that the legislation should hold digital platforms to account with tough penalties if they breach obligations. But when it comes to the question of liability, more questions need to be worked through before I can conclusively answer that question.
So you don't accept that digital platforms should be held liable and should compensate consumers if they're found to have breached their obligations under a code?
Potentially, Senator Walsh, and the Singaporean model that we've discussed is a potential model that could be explored. But again, we need to work through the details, and my my worry is that we are working to legislate this quite quickly without those details being worked through, leaving consumers and industry with questions as to how such a scheme would operate.
Thank you for the evidence. I think community expectations, of course, would be that digital platforms do, to use the term that you've used, step up and take responsibility where it is appropriate for them to do so, and provide compensation where there's been breaches, again, where it's appropriate for them to do so. I think that would be community expectations. The committee will take a break. We thank you for your evidence. The committee has agreed that responses to questions or notice should be provided by the 31st of January. We'd ask that you now disconnect from the video conference. Thank you.
Thank you, Sarah.
And the committee will resume at 2 p.m. The committee resumes, and I now welcome representatives from Choice, Consumer Action Law Centre and the Australian Communications Consumer Action Network. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, would you please state your full names and the capacity in which you appear today, and I'll go via order of the program, starting with Choice.
Hi, I'm Ashley De Silva, CEO at Choice.
Welcome. And Calc.
Stephanie Tonkin, CEO of Consumer Action Law Centre.
Thank you. And the Communications Consumer Action Network.
Hello, Senator. I'm Carol Bennett. I'm the CEO of ACAN.
Great. Thank you all for being with us today. Ms. Tonkin, do you have an opening statement that you'd like to give? And go ahead. Thank you.
Thank you, Senator. I will provide a brief opening and hand over to my colleagues, the CEOs from ACAN and Choice, for their brief openings. At Consumer Action, our lawyers and financial counsellors are speaking with scam victims almost every day. Members of Parliament from across the country, including yourselves, have also been hosting scam forums and hearing harrowing stories from your constituents about the life-changing impacts of scams losses. People's lives are changed forever from scams. $2.74 billion of Australians' money was lost to scams in 2023, $3.1 billion the year prior. ASIC reports in 2023 and 24 found victims are bearing 96% of this multi-billion-dollar problem, and there was almost no improvement in the consecutive years in banks lifting this reimbursement rate. Frictionless payments aren't required by law. They're a result of industry's attempt to offer a better product than their competitors. And yes, it's very convenient, but the degree of scam losses suggests that the offering isn't meeting consumer or the broader economy's needs. Building safeguards into transactions should be the cost, both financial and moral, of doing business. For years now, consumer advocates and scam victims from across the country have all been calling on government to follow the UK reimbursement approach to responding to scams. That model is working, and our argument is evidence-based. The UK Payment Systems Regulator most recently reported a 12% decrease in APP scam losses, even before the model was made mandatory late last year. Australia could do even better. We could introduce a world-leading modified reimbursement approach that also apportions liability for scam losses across the ecosystem, starting with telcos and digital platforms as well as the banks. This would be international best practice and protect consumers from devastating losses, as well as driving the level of industry investment needed to effectively prevent scams. That is, if business is on the hook for reimbursing scams, it will do all it can to stop them. But today, we find ourselves in a difficult situation. The reimbursement framework is not on the table. Prevention measures across the ecosystem are inadequate, and banks aren't meaningfully compensating their own customers when they fail to protect them from scams. Despite grave concerns with this bill, we are even more worried about the status quo continuing. Without mandatory laws mandating businesses to invest in the prevention and disruption of scams, and in a cost of living crisis, billions of dollars will continue being lost each year to financial crimes that only business can detect and stop. Scammers will continue to target Australia. We are well known as the world's honeypot for scammers. It is in this context that we support the urgent passage of the bill, but this is conditional on a key amendment to clarify liability for compensation. The Assistant Treasurer has repeatedly stated that business will compensate complainants when they fail to meet their higher bar obligations under the framework. The bill specifically lays out the opposite, that a consumer must prove that multiple corporations didn't meet their obligations under the framework and that the various breaches of various corporations have caused the loss. Consumer action lawyers and financial counsellors, and we're the ones who will be using these laws every day on behalf of victims, we are deeply concerned about the unreasonable burden on victims to fight and prove their unlikely case for compensation through internal and external dispute resolution. The Law Council of Australia, in its submission to this committee, has also highlighted that the laws, and I'm quoting, primarily will result in compensation being denied to the consumer. This is a David and multiple Goliath battle. Thinking again of your constituents who fall victim to scams, this is a fundamental flaw in the bill to the benefit of business. Scammers are innovative, well-resourced and sophisticated criminals. Ordinary people, we don't have access to the scams intelligence that only banks, telcos and platforms will see under the SPF. Yet the chances of compensation are still blatantly stacked against consumers. Effective dispute resolution is also critical to compliance with the framework, as a regulator cannot simply oversee or enforce every breach of obligations to the scale of this problem. So there are two parts to the framework. We are being told prevention measures set out in the government's bill will work and will be the best in the world. If that is the case, then what is the argument against industry being liable for losses when the prevention measures fail? This bill should not pass without clearly setting out liability for compensation. That is, specifying that if a regulated entity fails to meet an obligation under the framework, the consequence is a presumption of compensation for the victim's loss. We've set out 12 important recommendations in our submission to this committee that will strengthen the bill and go some way to addressing the extraordinary power imbalance and information asymmetry that is being imposed on scam victims by the framework. Some of those recommendations include maintaining the scope and effect of the e-payments code currently in force, where good precedent is being developed at AFCA. The bill allows for appeals to the federal court from decisions from the EDR scheme. This is unprecedented and undermines a cornerstone of external dispute resolution, giving deep-pocketed multinationals immense power in dispute resolution. They can just challenge a decision in a jurisdiction victims can't afford to defend. And compensation. There must be a primary entity responsible for compensating the victim, the bank itself or through a compensation pool, so that a victim doesn't have to spend even more time chasing multiple businesses. Thank you. I'll hand on over to my colleagues, perhaps Carol from ACAN first.
Thank you, Ms Tonkin. Yes, go ahead, Ms Bennett.
Thank you, Steph, and thank you, Senator. ACAN is the peak body representing communications consumers in Australia. We support the intention of the proposed legislation, which provides a framework for preventing and limiting scam activity. While we think the intention is sound, the legislation must be strengthened to effectively address harms from scams. The draft legislation provides a foundation for combating scams, but it needs strengthening in 3 areas from our point of view. Firstly, by adopting a presumption of reimbursement consistent with the UK model. Secondly, by imposing penalties for officers who make reckless statements regarding compliance of their company's obligations. And thirdly, by clarifying and strengthening the definition of reasonableness. With regard to the first, presumption of reimbursement for consumers, in the current draft, consumers must pursue reimbursement through arcane appeal systems rather than having the presumption of reimbursement from the outset. In effect, this places the onus on consumers who have in many instances lost their life savings, rather than putting incentives on industry to do everything possible to stop scammers. ACAN is of the view that the legislation should establish a presumption of reimbursement for consumers with exception for cases of gross negligence. This will incentivise effective prevention by financial institutions, telecommunications providers and digital platforms. This approach aligns with established economic theory, which supports allocating risks and costs to the parties that are best positioned to mitigate the harm, thereby reducing overall social costs. Banks in the UK have been voluntarily reimbursing scam victims at an average rate of 67% since 2019. That's increasing to 100% in October when new mandatory reimbursement laws come into force. By contrast, Australian banks only reimburse between 2 and 5% of consumer losses, according to CALC, and we've heard from Steph around that, but making the companies looking after our money and our transactions accountable for losing our money is the best way to reduce scams, as has been shown in other countries, including the UK, where 95% of scammed money is now returned to the customer by banks and other companies. And the number of reported scams is decreasing. In Australia, less than 10% of scammed or fraudulently obtained funds are returned to consumers, and scams are increasing. With regard to penalties for senior officers for falsely or recklessly certifying compliance, imposing strong penalties for senior officers who falsely or recklessly certify compliance with regulatory obligations ensures that the legislation envisions that senior officers providing certificates of compliance, which are critical to the integrity of the framework. The draft legislation should impose civil penalties on such officers where they make misleading, false or reckless statements of compliance. This reflects standard practice, where an individual is providing a statutory declaration, and it's consistent with similar penalties for making false and reckless statements to regulators and the courts. In our view, imposing clear penalties for misleading, false or reckless statements is critical to ensuring consumer and community confidence in the integrity of this framework. Finally, clarifying and strengthening the reasonableness definition. The current draft imposes an ambiguous obligation to take reasonable steps to prevent scams. However, it needs to go beyond mere adherence to an industry code and include a principles-based obligation in the legislation. The rapidly evolving scam environment means that tying the substantive obligations to protect consumers from scams to a code will undermine the achievements of the objectives of this framework. In our experience, codes rapidly become obsolete and may take years to be updated, even in circumstances where issues or deficiencies have been repeatedly identified by relevant stakeholders. For example, the current revision of the Telecommunications Consumer Protection Code has been ongoing since June 2023. There's no resolution on demonstrated problems, such as aggressive sales practices or weak credit assessments so far. Instead, the framework should retain a broad principles-based obligation to take reasonable steps, supported by an ecosystem of detailed codes addressing the identified and known risks in a systemic fashion. So by providing further clarity on the intended scope and operation of the reasonableness definition, we can provide greater legal certainty for consumers, for industry and regulators. In essence, if a risk is foreseeable and capable of being addressed by a regulated entity, it's reasonable to expect action by the entity to address the harm.
I just want to clarify that we don't have time for 3 5-minute opening statements. So I'll just have to ask you to draw it to a close and just give Mr. De Silva a heads up too that we need time to ask questions. Thanks, Ms. Bennett.
No problem, Senator. There is just one other comment I would like to make in relation to comments that we've heard today about quadruple jeopardy. And basically, we believe this is a misunderstanding of the legislation, but I won't go into that now. But I would like to close by saying too many ordinary Australians are falling prey to domestic and international criminals who increasingly are using clever deceptions to steal life savings, home deposits and superannuation balances. These days, taking common sense precautions and having your wits about you isn't always enough. We urge parliamentarians to put consumers first by strengthening this legislation if we want to dispel our place as one of the most scammed countries in the world. Thank you to you, Senator, and the committee for the invitation to appear before this inquiry.
Thank you, Ms. Bennett. Mr. De Silva.
Thanks, Senator. The services provided by banks, telcos and digital platforms have been exploited by scammers operating beyond the reach of our legal system for years now. Scammers have flourished because big business has been allowed to prioritise increasing market power and profitability with little to no regard to the safety and security of consumers in Australia. Major digital platforms are operated by multi-billion-dollar companies with the most advanced technology at their disposal. There's little they don't know about their users, but the rate that scams have proliferated on Google and Meta platforms makes it abundantly clear these tech giants are choosing not to adequately invest in scam prevention. Digital platforms take an approve first and ask questions later, if ever, approach to publishing ads. As digital platforms are paid directly by scammers to promote scam advertisements, there is an inherent conflict between the financial interests of digital platforms and the safety of their users. These businesses have the technology to prevent most scams, but they're not required or incentivised to do so under our current legal framework. To fix this, we really desperately need laws that shift the financial burden of scam losses from victims to the businesses enabling and making money from the scams. The Scam Prevention Framework Bill before the committee contains crucial legal obligations for digital platforms, banks and telcos to take reasonable steps to detect, prevent and respond scams from occurring on their platforms. These obligations are desperately lacking in Australia's current laws, not just for the 3 sectors the bill would immediately apply to, but also for others like superannuation, crypto platforms and online marketplaces. All of these businesses should have been bound by these obligations to consumers years ago, and their introduction really mustn't be further delayed. Every year without obligations means billions in scam losses. And for this reason, we urge the committee to recommend that the bill be passed as a matter of priority next month. If this doesn't happen, more consumers will suffer scam losses due to the failures of businesses and the inaction of government. However, as noted by Consumer Action Law Centre, we also have concerns about the workability of the dispute resolution process for consumers under the bill as it's drafted. Victims of scams must be able to rely on AFCA to deliver justice where a business has not done enough to prevent scams. Victims should not have to be experts in financial services or technology to do this, and we're concerned the bill as it's currently drafted would not achieve this. And finally, failing to address these concerns about dispute resolution by the amendments recommended in the joint consumer submission would be a significant opportunity missed and will greatly reduce the value of the laws. We urge the committee to take these recommendations seriously and for Parliament to come together to pass a strong bill that comprehensively addresses the significant issues of scams. Thank you.
Thank you very much. Just a question for you, Mr. De Silva. I mean, the scam prevention framework bill that's in front of us today would be the first of its kind in this country. It would impose obligations on banks, on telcos, on digital platforms, and it would apply penalties if those obligations are not followed. We know that AFCA will be designated as the external dispute resolution body, and will have powers to enforce redress for consumers. There's been a range of views put today. What do you see as the consequences of the bill not passing as a priority?
So look, I think the reality is that the harms that occur from scams are occurring daily and have been for such a long time and causing real impact on the lives of not just a few, but many. And so this is this difficult balance for us, and you can hear it in the different statements before you today of recognising that we have concerns that consumers navigating that process will find that they aren't getting the best outcomes and that there is too much without the presumption of reimbursement. It leaves the burden on consumers to navigate actually judging what reasonableness looks like, and that we've got concerns about that. So that would be our preference, that we move forward with those amendments that Steph outlined. But we face this difficult point as a sector of also being very dialed into the reality that Steph and Carol have shared, and recognise that there are steps forward here. If we were to move forward with it as it's currently drafted, then the minimum would have to be that we put a lot of effort into getting the codes right, though, as Carol said, that's not a foregone conclusion that will have a lasting impact. And we'd really need to come together around the review in 3 years' time and pay particular attention to the risks that we're outlining, which is, while this is being proposed as something that is prevention oriented, it won't capture all scams, and we really need to understand and see the effects of the times in which it doesn't.
Thank you very much for that. Ms Tonkin, one of your key concerns and an enhancement that you wanted to see was clarity around the ability to apportion liability to different players in the ecosystem. Just want to make sure that we understand your evidence on this. So under the framework, the Minister would have the power to provide guidance on how to apportion liability between the regulated entities that have breached their obligations. Given that, what's the clarity that you would like to see around the ability to apportion liability?
So there's two things. The first is we need clarity overall in terms of a consumer's ability to seek redress in the first place. So right now it's that David and Goliath battle of someone having to somehow get all the evidence and prove the case. So that's a fundamental flaw, we say, in the legislation, and it's not just us. The Law Council as well has pointed that out. So that's one overarching, that we need to have some presumptions in the legislation, like other laws in this country, where there's such a vast information asymmetry. There's usually a presumption flipped the other way in the favour of the consumer. The second part is around apportionment, and one of the amendments between exposure draft and bill stage was the introduction of a provision which specifies that the Minister will make rules around apportionment. So we think that's good. And we do think that apportionment is a good way to drive that incentive on businesses to invest in prevention. The issue we have is, and with a lot of this framework, is we are asked to take a very big leap of faith on this. We don't know how the apportionment is going to be set out. We don't know which way it's going to go. We look forward to consulting on that and putting consumers at the centre of that regime. One major concern that I have and that we have is that a consumer may not be made whole. And so what that means is if a scam originates through a SMS and then it comes through and there's sending bank and receiving bank involved in that scam chain, if the telco is found to have breached their obligations under the framework, but the banks both met their obligations, does that mean the consumer is reimbursed the 20% that's set out in the rules because the banks have both met their obligations? Or does the telco reimburse 100%? And we say it should be 100%. The consumer should be made whole. And that's the approach that, for example, Malta has taken as well. So there's a few things in there. Again, it also remains to be seen what those rules look like. But I know a lot of thought and consultation will go into those too, and we look forward to taking part.
Yeah. Thank you. And just a question for you, Ms Bennett, before I give the call to Senator Pocock. We did have the industry at the hearing earlier today, banks, telcos, platforms. You went to your opening statement about the Communications Alliance assertions around quadruple jeopardy being incorrect, noting that the bill is a framework that sets up further work, as Ms Tonkin has just said as well. But what's your response to that quadruple jeopardy assertion?
Well, thanks, Senator. I think it misunderstands the legislation. The presumption here is that the quadruple jeopardy requires the actions of ACMA, the Australian Communications and Media Authority, the ACCC, the Australian Financial Complaints Authority, and then the liability imposed by civil penalties as all being part of this sort of 4-point quadruple jeopardy that the industry seem to be concerned about. This legislation is really talking about codes effectively dealing with the known risks. So it requires telcos to comply with an industry code in service of complying with an overall requirement that they take reasonable steps to prevent scam activity. So, just as in road safety, where we individually regulate risks like speeding and drink driving, those regulations are supported by broader rules for misconduct for things like negligent driving, which capture specific cases, all in the service of promoting community safety. So put in simple terms, the argument that if the industry were to act negligently and cause some kind of significant harm, but they obeyed the speed limit by meeting the procedural requirements, then the community should just wear the level of harm imposed. We think that argument is untenable. It ignores the fact that the industry is best placed to mitigate the risks that are faced by consumers from scam activity. So we think that it really doesn't mean that they can obtain more compensation, consumers, than they are due. It's just not an argument that we believe has any kind of validity.
Okay, thank you very much for that. Senator Pocock.
Thank you, Chair, and thank you all for your time and your submissions and all your work on this. Ms Tonkin, your submission points to the uniquely Australian reimbursement model being the preferred option. Can I ask what the difference is between this and the Scam Prevention Framework Bill that is before the House?
Yeah, absolutely. Quite a bit. What we propose is the Australian reimbursement framework would put all of the businesses in the ecosystem, so the telco, the bank, the digital platform at the outset, will put them on the hook for reimbursing the consumer's loss. And the whole point behind that, and this is the same as in the UK, the whole point behind that is if a business is on the hook for reimbursing scam losses, they're going to do all they can, not only right now to reimburse scam losses and to invest in those measures to prevent scam losses, but also they're going to have to continue to innovate like the scammers are continuing to innovate. And so they're going to have to continue to keep protecting their own customers and users. So it's a simple kind of economic 101 theory, but it's proving effective in the UK. The alternative that we have here is there are a set of obligations in the framework, and if a business fails to meet those obligations, then a consumer can bring a case and can try with the evidence that they can get their hands on, remembering a lot of this is commercial and confidence information, to somehow prove the case against the business. They not only have to prove that, say, a bank has failed to meet its obligations under the framework and the telco and the platform, but they also have to prove that that breach caused the loss, which, again, coming back to apportionment, is going to be a very difficult argument to make. I think it's an oversight personally in the legislation, and I think that's where the Law Council of Australia's submission went as well. And yeah, we think that it's not a dichotomy of pass this legislation or don't and go with the reimbursement framework. Like, we have the opportunity now to improve this framework if this is what we're stuck with. We don't think it's the best. We still think that reimbursement framework would be world leading, absolutely. But if we are working within the Scams Prevention Framework Bill, we've got to make those amendments to add a presumption of compensation. Otherwise, the dispute resolution won't work. And again, to Senator Walsh's question around the quadruple jeopardy, in a regulatory framework, you've got regulatory obligations enforced by a regulator, but they can only enforce the big ticket things through enforcement proceedings. They can only take certain steps, and deterrence only goes so far. For smaller businesses and lower level breaches of obligations, they all fly under the radar, and that's the value of dispute resolution. That's why we need to have those two things working hand in glove.
Thank you. And who do you see most impacted by scams in your work?
Well, we see there's a scam for everyone, but quite interestingly, the path through which we hear from scams victims most is the National Debt Helpline that we operate in Victoria. And we hear people calling up, not always about their scam, but in fact about not being able to pay their rent or meet their mortgage. So it's a real, it connects in deeply with the cost of living crisis that so many of your constituents are feeling the pain of right now. So we are hearing from people from retirees to young couples who've lost their deposit of their house, through to a single mum who now is struggling to put food on the table because she's lost her savings buffer. So there's a scam for everyone. I also have spoken with people who work in some of the cyber teams in the big corporations who've also been scammed. It's a wicked crime with resource criminals, and that's why these laws have to be the strongest possible.
And if the Parliament did for some reason decide to pass the bill as is, what does this framework, if passed as it is, mean for an organisation like yours that represents scam victims?
So our lawyers and financial counsellors, and we've been talking really closely about how this framework would work. We would have to somehow try to gather that evidence and somehow try to prove a case. The internal dispute resolution timeframes will blow out, as well. A lot of arguments would have to proceed from internal dispute resolution to external dispute resolution. We're going to see not only time delays but pressure put on the Financial Complaints Authority. I know that they'll work out the most efficient way possible to deal with this, but the sheer volume of scams and complex disputes between multiple entities, and a scam victim who doesn't even know what happened, because that's the nature of what presents to us. It's people who have no idea how they've lost the money. If they knew, maybe they could have, taken steps to protect themselves, but that's not the case. So we're concerned about the influx of people coming to us. We're concerned about the complexity of the work and almost the impossibility of the task of proving a case under this framework.
Thank you. And then just finally, I was interested if you could expand on, in your submission, you pointed out concerns about appeal rights to the federal court.
Yeah.
Why is this a concern?
So fundamentally, external dispute resolution, the value and the strength of that entire system is that you have an even playing field, sort of, between the consumer bringing their case and the multinational corporation that they're bringing their case against. So if it's a scam victim and a bank, that's a really significant difference between power and resource capabilities. And so the whole idea of external dispute resolution is you bring your case, it's determined, there's an independent arbiter who can support as needed, and you get a determination, and that's fixed. If you have a threat of appeal to the federal court, that fundamentally shifts the power dynamic in that dispute. A consumer is far more likely to settle, and we see banks urging their customers to settle their claims for small fractions of what the scam loss is, only for those cases from internal dispute resolution, escalating through to external dispute resolution, and the full amount being awarded by the Financial Complaints Authority. So if you've got the threat of litigation looming, why would, that power dynamic completely shifts. And I think we are really concerned that a case like the recent HSBC scam, where HSBC, the AFCA noted the actions of the bank and how it was quite, I can't think of the word on my feet, but it was almost aggressive in nature, the way, overly legalistic and litigious, the way that the bank acted. Speaking with some of my colleagues in the sector, we're certain that HSBC would have appealed that decision if they had the chance. And so in that case, if you've got the threat of appeal, people are going to settle. People are not going to have that fair hearing that dispute resolution offers. And if we start to crumble it here, where else is it going to start to crumble?
Thank you.
Thank you. Thanks. I just noticed that we're running a bit behind time and we'll need to make up some time. Senator Smith, do you have questions for this group? Senator Smith.
Thank you very much. I do. Why is it that Australia is not adopting the UK model?
I can start with that.
Thank you. Yeah.
Look, it's really disappointing. We have consumer advocates and victims nationally have all been calling for a UK-style reimbursement model. What we have on the table is untested and requires a leap of faith, truly. And so we're very concerned that this hasn't, that the model that's proposed hasn't put the scam victim and consumers at the centre. And it is very much focused on prevention, which is really important, but it ignores the preventative and the incentives that a reimbursement framework would bring. We're also concerned that Treasury didn't consider a reimbursement framework in its impact analysis. It only considered introducing the scam prevention framework and not introducing it. I think there's a gaping hole of an alternative as well that wasn't costed up at all.
Would others like to comment?
I would say, Senator, it is an interesting question. And certainly when you consider, as Steph just pointed out, that Treasury hadn't considered this, when basic, or not basic, but established economic theory would suggest that a model that allocates risks and costs to the parties that are best positioned to mitigate harm and reduce those costs of scams is best placed to do this. So it doesn't make sense. It does really put the onus on consumers to sort out and have to litigate and pursue claims that they simply don't have the information to pursue and are unlikely to have the information. So from our perspective, that's a very good question. It's the fundamental question. Why aren't we doing this? The UK's done it. It's tried and tested. Why are we falling behind? And to us, it's a no-brainer. We should be focusing on presumption of reimbursement if we're going to get this right, and if we're going to address the escalating harms that we're seeing from scams in Australia as one of the most scammed countries in the world.
The Senate will have to make a decision on this bill next week. Given the serious deficiencies in which you've identified, given the fact that consumers are really paying two sets of costs, they're paying the cost of the scam and then they're paying the cost of having to pursue the compensation, should the bill be agreed to in its current form next week by the Senate?
Well, I think actually, Ash, you put it really well in your opening that the status quo of business, a lacklustre investment by business in scams prevention and a lack of reimbursement, 96% of scams losses are being paid by victims, not by industry who are placed to prevent them. The problem is, without that level of investment, and if we're delayed a further year or 2 years, my organisation is going to speak to thousands more people whose lives are ruined. So we're in a really difficult position, and so we do want to see some scams laws passed, but they need to be strengthened. They must be strengthened. The dispute resolution really is not going to work, and it's going to leave scam victims harmed and paying the cost. And again, I just repeat, if the prevention measures are going to work like what we've been promised and we're being told, then there shouldn't be a huge reimbursement bill at the end of the day. And what I don't see the issue with business being accountable for reimbursing victims. It's what should be done.
Do you have a last question, Senator Smith?
I was hoping Ms Bennett might comment, and then I do have a last question. Yes, yeah.
Look, I agree with Steph, Senator. I think we need to be acting firmly, strongly. We probably need to see some changes that strengthen the bill, and we'd like to see changes in those areas I've outlined specifically, but there is room to improve this. There is room to get this right. We have an opportunity and we should be leading the world, not following it. If we don't presume reimbursement, in our view, we are following, not leading.
What commitment has the government or the Treasury given that your concerns, proposals for improvements will be adopted?
Insofar as our key concern around introducing a presumption of compensation, which really is the best of, a bad situation, we understand they're looking into it.
What does that mean?
I believe that they're seeking advice from Treasury on whether it could be introduced or not. And
so the government is seeking advice from the Treasury on the suitability of adopting the presumption of compensation.
Look, I think all I know is that they're seeking advice on it.
And the government, and by the government you mean the Assistant Treasurer's Office?
That's right.
We'll be able
Bennett,
to
is that
ask
your understanding as well?
these questions shortly.
That's your understanding as well, Ms Bennett?
Yes.
Thank you very much, Senator Smith. Yeah, thank you, Senator Smith, and thank you very much to the witnesses on this panel. Thanks for your evidence. You go with our thanks. Thank you. I now welcome representatives from the Australian Financial Complaints Authority.
We're not on.
And that information on parliamentary privilege.
Can you get something quick? Yeah. We're on mute. We're on mute still.
Sorry, Mr. Locke, we can actually hear you right now.
Oh, you can hear us? Oh, I do apologise. I'm very sorry. Very sorry.
So that's good, and you're not on mute. That's okay.
Okay, you can't.
I am welcoming you, and I'm letting you know that the Senate's resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matter of policies, reasonable opportunities, etc. I think you know the drill. For the Hansard record, will you please state your full names and the capacity in which you appear today?
Yes, certainly, Chair. My name is David Locke. I'm the Chief Ombudsman and CEO to AFCA, and I'll let my colleague introduce herself.
My name is Dr. June Smith, the Deputy Chief Ombudsman at AFCA.
Welcome, Dr. Smith. Welcome, Mr. Locke. Do you have a brief opening statement that you'd like to give?
Yes, I do, Chair. We really welcome the opportunity to appear before the committee today. The Australian Financial Complaints Authority, as you're aware, is the independent ombudsman scheme for the financial services sector, and we are a not-for-profit organisation. Our role is to independently resolve disputes that consumers and small businesses have with financial firms, and in doing so, we identify systemic issues and serious contraventions of the law and report those to the relevant regulators. AFCA has handled over 470,000 complaints since we started in November 2018. $1.38 billion has been returned to consumers and small business owners through our dispute resolution work. The ACCC reported that Australians lost $2.74 billion to scams in 2023, and those are the latest figures that they have published. That astonishing figure hides in its sheer scale the heartbreaking stories of financial loss, the dissipation of money hard-earned, of housing deposits foregone, of life savings completely vanished. It isn't just the money that's lost, which is often life-changing amounts. What we also see day in, day out is the loss that people have of any sense of security, the humiliation of being tricked, and a diminished trust in the fairness of our financial services system. Sometimes with older Australians, this can be devastating in terms of their confidence and ability to continue independently. And daily we see the life-altering impact that scams have. In the last financial year, ending 30th of June 2024, we received over 10,000 scam cases, an average of 900 a month. And this was an 81% increase on the previous year. Despite the surge in complaints, AFCA resolved scam complaints in an average of 57 days. And of those cases that didn't resolve between the parties early in the process and went through to investigation, 60% of those resulted in full or partial compensation for the consumer. The one piece of good news is that the volumes of complaints coming to us with regard to scams started falling in the last 3 months of 2023-2024. And this trend continued in the first half of the current financial year. We believe this work can be attributed to the work of the National Anti-Scam Centre, joined up work taken by industry and by regulators, and we think that this is already having a positive impact. Having said that, though, the level of scams still remains too high, the harms are immense, and in our view, the legislation before the committee is vital. Our experience in handling scam cases shows that the current legislative and regulatory settings are inadequate and not fit for purpose. Too often we see poor conduct, poor systems in our financial institutions, inconsistency in the application of prevention measures in response to the barrage of scams that Australians are facing. We also see a lack of clarity of roles and responsibilities, and as a result, we welcome action to address the immense harm caused by scams through prevention and also by filling gaps in the law and codes of practice that make it hard for scam victims to access proper redress. AFCA strongly supports the establishment of a whole-of-ecosystem response to scams as proposed by the bill. Importantly, this framework brings in the sectors needed to effectively disrupt and prevent the proliferation of scams. We support the urgent passage of the Scams Prevention Framework Bill so that the significant work that needs to follow to implement the framework can begin. Without this enabling legislation, that just will not proceed. Under the framework, it's intended that AFCA will be authorised as a single external dispute resolution or EDR scheme for the first 3 designated sectors. Our submission sets out our experience as well as our commitment to building the capacity that will be needed to take on this new jurisdiction. We will leverage our experience in not only resolving complaints, but also in supporting financial firms and other firms to improve their practices through data and insights. We're under no illusion that a lot of significant amount of work needs to be done to establish the first scams EDR jurisdiction. But I would like to firmly reaffirm AFCA's commitment to work with all the stakeholders to deliver a robust, fair, independent and efficient process that is consumer-centric and that is in line with the principles and objectives in the bill. A significant body of policy development work needs to be completed by the government and regulators to deliver a strong scams protection framework for Australians. We are ready to play our role and step up to assist. Without this legislation, if Parliament chooses not to pass the legislation, Australians will continue to lose millions of dollars. The emotional toll and life-changing consequences will continue to impact individuals, families, and small business owners. We will lose an opportunity to significantly move forward and enhance Australia's efforts to detect, disrupt, and prevent this evil traffic if this legislation doesn't move forward. The bill, of course, lays out the foundations, and as I've said, an awful lot needs to be done, but it lays out the foundations, brings in the key players, and enables a whole programme of work to be undertaken and joined up work, which we think is essential if we are to really make the progress that's needed. We believe that collectively we can make Australia the world's hardest place for scammers, and AFCA firmly believes we need to take this step forward now.
Thank you very much, Mr. Locke, for your opening statement and your explanation of AFCA's existing work in the scam space and the work that you would undertake under this bill. The bill establishes AFCA as the single EDR, or it is known that AFCA would be the single EDR for each of the designated sectors. Can you explain to us how AFCA would operate as an EDR across these sectors and what powers would be available to you and perhaps already are available to you as well under your existing legislation?
Yes, thank you, Chair. And AFCA already has significant operational experience just in the 7 years of operation to date in relation to expanding AFCA's jurisdiction, first of all into legacy jurisdictions when requested to do so by the government, to establish a compensation scheme of last resort when requested to do so as well, and in the division of its jurisdiction into a superannuation jurisdiction as well as for general complaints as well. So we have extensive operational experience that we think will hold us in good stead there, and expanding our jurisdiction into new sectors and onboarding new member firms is something we do all the time, including this year where we will take on buy now, pay later and payment providers as well as cryptocurrency providers as well. We've got extensive experience in handling matters related to joinder and multi-party complaints, whether that be bankers and agents, whether that be financial firms and managed investment schemes, or whether now that be financial firm, receiving bank, telecommunications provider and digital platform. 104,000 complaints handled in 1 year last year, so we can manage high volumes of complaints, 11,000 of course of which were scams complaints. We also have adapted and evolved our operating and funding models, and in our submission we set out a visual frame for how we see the respond pillar indeed operating under the principles in the framework where, like now in the financial services sector, there is a primary responsibility on the firm to ensure active, early and timely intervention to respond to consumer concerns. And in that way, of course, develop in some instances for digital platforms and telcos, but for financial firms, they have significant experience in internal dispute resolution processes, which are not new. There are international standards for internal dispute resolution. It provides all entities with opportunities to look at root cause analysis, consumer experience, as well as dispute resolution. And to take on the success of remediation and redress programs that were established after the Federal Royal Commission into financial services misconduct, which delivered billions of dollars to affected consumers through financial misconduct. We think those elements that can be developed under the principles and the rules and the codes framework can assist, support and build foundation for early timely resolution of complaints where consumer harm has been identified, and then AFCA will step in with its specialised and universal EDR assessment and determination of liability in complex disputes. So we know that you have before you some amendments, one of which is certification of compliance, which we think would be a useful tool. Another is the evidence before you around apportionment of liability and decision tables, very similar to the ones Singapore, Malta, and other jurisdictions use. We think they too are useful tools to assist in universal dispute resolution, but it must be one in, all in, with a simple consumer-centric model where the consumer and the harm caused to the consumer is handled first by the firm.
Thank you very much for that answer. You have gone through the figures on how many consumers you assisted with scams in the last year, and also the proportion for whom a full or partial compensation was achieved. One of the matters that's been raised in the inquiry today is whether there needs to be a presumption of reimbursement under this framework for AFCA to be able to get results for consumers. Are you able, from your experience and the work that you've done, to give us an assessment of whether a presumption of reimbursement would be required to get results for consumers?
So we understand that the overarching objective of all parties and all stakeholders here is to ensure simplicity in the process, particularly for consumers trying to access all elements of the pillars, particularly respond. In this instance, civil liability provisions are not new to the law or to frameworks such as these. So the questions you ask, Chair, are very relevant to be put to Treasury later on. But in this instance, one of the tools for shifting onus and accountability to the financial firms is the certification mechanism that's been talked about. Another is through AFCA's powers, which already include the power to seek information, documents, videos and other evidence in support of either a case or a defence to a case, and to ask questions through our inquisitorial jurisdiction, which we have, remembering that AFCA is a free, informal external dispute resolution scheme, not a court. So while we don't have the powers to compel, we can request information, and we can also make decisions where we provide an adverse warning to a party that refuses to provide the information needed, and can make adverse findings where that information is not forthcoming. We've also seen situations where financial firms historically have been can be litigious in nature and very defensive and stridently so. And we've had the ability to level that playing field by awarding professional costs to consumers and also non-financial loss, where that stance and that culture has caused further or additional harm to consumers. So civil liability provisions are not new. There are ways to ensure there is a balance of information symmetry between the parties and to ensure balance in their ability to engage in a fair process, particularly the EDR. So these things need to be worked through, but that certification requirement as well, firms to certify that they have complied with the principles and their codes, while not an absolute defence, goes some way to ensuring that they are at least accountable and have looked objectively at whether they have met their obligations.
Thank you, Dr. Smith. I'll go to Senator Smith.
Thank you very much, Chair. Could you explain how the scam preventions framework will interact with the existing e-payments code?
Well, I think that needs to be determined, Senator. At the moment, the e-payments code applies only to banks who have subscribed to it, and not all banks have. For example, I could name a large bank that isn't a subscriber to that.
Please do.
Also, Macquarie Bank, as I understand, is not a subscriber to the code. It really also only deals with transactions which are classified as unauthorised transactions. So it only deals with some matters. It's quite limited in terms of its application with regard to scams. And so I think there is there's a policy question really for government to determine whether the payments code continues to apply, or whether actually the banking code that will sit under this really covers all situations that relate to scams. So that is an active consideration. But at the moment, when we're dealing with matters, the only thing often that we've got that we can look at is actually the terms and conditions of the bank and the payments code. And as we've said, we're getting thousands of cases where we actually do not have any clarity really on the legal liability position. We can also, at the moment, only look at the consumer's own bank, which will be the bank that has often made the transaction. We don't have jurisdiction at the moment to look at to deal with receiving banks, because the consumer doesn't have a contractual relationship with that receiving bank. That is something we have spoken to government and others about and may separately be dealt with. But I think it just indicates, and of course we can't look at the conduct of other parties. And our experience is that most of the time consumers are either actually getting caught up in a scam due to online activity, or they are being approached and there's been a solicitation effectively through telecommunications providers. So we noted the BDO scams reports that Westpac included in their submission, which said that 48% of times primary solicitation was through telecommunications companies, and 47% of losses were attributable to scams initiated online. That didn't surprise us. It broadly accorded with what we're seeing as well. Of course, we have no jurisdiction at the moment with regard to any of those players. It may be that you have a situation where actually the bank has, acted with real care and diligence, and actually really the responsibility for this should sit with the provider that's allowed, online advertising of these sorts of activities.
I would have thought that the policy question around the applicability of the e-payments code rules would have or should have been resolved by now.
Senator, they are things to still be worked through, and a question that would be relevant to the evidence to be given by Treasury as to where progress sits at the moment.
Because it's a policy question, does it mean that if that policy matter is not resolved before the calling of the election and the imposition of the caretaker period, does that mean that that matter would be outstanding until the resolution of the election and the appointment of new ministers?
Well, at the moment, Senator, the situation is the SPF legislation is before this committee. The e-payments code is still in operation, so it's a matter that needs to be clarified. It's not.
So
we are saying that it's a matter that could be. We are saying that it is a matter that could be resolved before the legislation is passed, or with the legislation passing, but that is to ensure there's clarity of which legal framework would respond in particular circumstances. But it's a matter that could be handled later on.
My point is, but the matter could be delayed from being handled if there's an election called and imposition of a caretaker period. So if this bill
it could be considered later, Senator, certainly by whoever is the Minister of the day.
But only if they are the Minister of the day and there is no caretaker period. Ministers can't make decisions during caretaker.
No, that would be correct. But you know, the intention with this, if the legislation proceeds, AFCA would do everything in its power to have the dispute resolution.
It can't break the law and it can't make the law.
No, indeed, Senator, and of course the
so just help me understand which
operate.
Code would have priority, Mr. Locke. Which code would have priority if that matter, if that policy question was unresolved?
If, as matters stand today, Senator, if we had a complaint before us and the e-payments code was still in operation, AFCA would need to assess the relevant law to examine for the particular case in hand. At the moment, the e-payments code would only apply to a particular limited number of scams against the transactional bank if it were a member of the e-payments code in circumstances where the transaction was unauthorised. So we would need to look in those situations as to whether it was more appropriate to apply the e-payments code or the SPF framework. Our point being that that is a matter that we think could be tidied up earlier, given the overarching objective of all parties is that there be a simple, universal, consistent framework that will respond to all scams in the macro environment.
I'm talking,
thank
you, Dr. Smith. I'm talking about the practical matter of guidance or policy matters being resolved, being informed to AFCA and others prior to an election being called, and the subsequent delay that is created if those matters are not resolved prior to the calling of an election. Of course, the Prime Minister is free to call an election at any point at this point.
A last question.
So, no, I think I do have a couple of more other questions, Senator Walsh. My next question is there a time? Excuse me, Senator Walsh.
Don't talk over me, Senator Smith. I will be moving to Treasury.
Senator Walsh, I'm asking my questions.
Yeah, I'm attempting to chair and move to Treasury. You do have a final question and the ability to put questions on notice. Thank you.
Will there be a time limit for the making of a complaint to AFCA?
At the moment, under AFCA's existing rules, Senator, there are time limits that apply to the lodgement of a complaint. While AFCA's rules for the handling of scam complaints under this framework will need to be developed over the next 12 months to March of 2026, we anticipate that those time limits may be looked at as 6 years from date of conduct to lodgement, or 2 years from IDR. But in our submission, we have been explaining that we think it's time to reimagine external dispute resolution, that scams may be one of those areas where you're looking at far more restricted timelines for the bringing of a complaint, also the addressing of a concern by a financial firm and its handling at AFCA. So it could be much shorter timeframes than 6 years, Senator.
When do you expect the scheme to be in full maturity,
Thank
When do you
you.
expect the scheme to be in full maturity?
Thank you, Dr. Smith and Senator Smith. Before you say this to me, Senator Smith, I did only ask 2 questions myself of AFCA, and you do have the ability to put them on notice. So thank you very much, Dr. Smith and Mr. Locke. We very much appreciate your time today. Answers to questions on notice that you may get from Senator Smith are due by the 31st of January. We ask that you now disconnect from the video conference. Thank you very much.
Thank you, Chair. We're very happy to answer those questions, Senator, on notice.
Thank you.
Thank you.
I now welcome representatives from the Department of the Treasury. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. The Senate's resolved that an officer of a Department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. The resolution doesn't preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. You're also reminded of matters pertaining to public interest immunity, with which I'm sure you are familiar. For the Hansard record, would you please state your full names and the capacity in which you appear today?
Tom Dixon, Department of Treasury, Acting First Assistant Secretary of the Market Conduct Division.
Shelley Davis of the Treasury, Acting Assistant Secretary of the Consumer Branch.
Thank you both. Did you have any opening remarks, or are you happy as usual to proceed straight to questions?
Happy to proceed to questions.
Okay, thank you. This framework introduces a cross-sector approach to scam prevention. Can you unpack why the bill has adopted that cross-sector approach and how it would be effective?
Certainly. Thank you for the question, Senator. So the reason why we take, why the government is deciding to take a whole of ecosystem approach is in recognition of the fact that scams are prevalent across a number of sectors in the economy. So there are multiple points at which scams enter the system, and by focusing on all of those points of entry, you're maximising the ability to harden up all of those systems that would prevent scams from occurring in the first place. It's targeted to the areas that are most prevalent, so it focuses on, in a way, on trying to minimise the regulatory burden, but at the same time maximise its effectiveness. There are, in terms of alternative approaches, we've seen suggestions that models could focus on other things, such as only in relation to perhaps just one sector of the economy, and we've seen models around the world where they might only focus on a small segment of scam activity. And this approach that this government is taking is attempting to look at a much wider scope of scam activity and many more sectors in order to protect the most number of consumers.
Okay, thank you. We've heard a lot in the hearing about compensation for scam victims. Could you explain how compensation would work under the framework?
Certainly. So in the bill as it stands, there are new rights and obligations that are created in the law. And as you've heard previously from, for example, AFCA, they've pointed out that their jurisdiction is actually quite constrained. What the bill does is it enables consumers to explore a number of different avenues for redress. Those avenues you would see in operation in other contexts in the Australian economy. So as you would expect, there's internal dispute resolution and new obligations that would help make sure that that process is as effective as it can be. Then there are external dispute resolution processes. And then, of course, as has been pointed out in previous testimony, there's a need to assist consumers so that they're not doing this by themselves. And so that's why there are additional responsibilities that AFCA is able to take on board. So there's assistance from AFCA in assisting with the external dispute resolution process. And in addition to that, there's additional regulatory oversight. So the ACCC can also assist consumers in this space, including by taking on cases that have systemic merit. So there's a range of avenues that consumers can benefit from under the bill.
Thank you. We received evidence from industry who would be regulated by the bill, by the framework, that obligations under the code, the industry codes that are established, could conflict with obligations under the principles overseen by the ACCC. There was a concern about incurring liability for both differently. Will industry be liable for a sort of a dual obligation, as has been raised today, particularly by the Communications Alliance,
so
where they talked about a quadruple jeopardy?
So an interesting point in the bill is that there's actually a provision that explicitly talks about double jeopardy and preventing civil penalties being imposed for the same conduct in two different circumstances. So in addition to that, though, I think what would bear out in reality is regulatory pragmatism, in the sense that we do have regulators that are forming judgments about how they should pursue particular types of conduct. And so it's well within the powers of regulators to actually examine those cases and ensure that those cases of overlap don't result in an over-penalisation for misconduct. Okay. Are you able to step us through the consultation process that's gone into the bill, and what are some of the key changes that have been made from the exposure draft to the introduced bill? Perhaps just some of the major themes of changes from exposure to the present. So going back to 2023, so in November around that time, there was consultation that was undertaken in relation to codes. We had public submissions received in relation to that. That consultation closed at the beginning of 2024, so I think 29th of January 2024. We then did a further consultation, which was undertaken around September 2024 through to October. That was consultation on draft legislation. And so, we've been consulting, of course, for quite some time. We've had, any number of engagements. We've been doing it quite broadly with a whole range of industry bodies, and considering submissions, from quite a number of parties. So they're the highlights, but I'm happy to add, or my colleague might have further to add.
Look, I think just beyond those two formal consultations, I would just point out that throughout that period we've had fairly regular engagement with various industry representative groups, with the members that are representing consumer groups, with individual businesses, outside those formal consultation processes, as well as regular engagement with the regulators that are intended to have roles and functions under the framework. Turning to your question about sort of key changes between the exposure draft and the bill that was introduced into Parliament, I would summarise that feedback, quite a lot of feedback on the exposure draft bill went to practical or implementation challenges. And so we've looked in giving government advice on changes to the bill. A number of changes have been made to address those areas. So we have looked to address matters that were raised by quite a number of industry groups around the interaction between the primary legislation and the codes, to clarify the elements of what will be considered reasonable steps that are required for them to adhere to their obligations. The bill introduced to Parliament also has a number of changes made to key definitions of the bill, including the scope of the definition of consumer and scam, which sought to address feedback from both industry, consumer groups through the bill. And we've also looked to adjust the elements and the detail included in the principles in this. As you've heard in other evidence today, we do want industry to be subject to codes that are specific to arrangements and the role that that industry plays in a scam life cycle. And so the bill itself has been elevated, and the principles have been some of the content that was initially proposed in the principles has been removed, with the intent that as codes are prepared and drafted, there'll be further engagement with relevant sectors and other stakeholders so that detail appropriate to that industry's role can be brought in.
Okay, and just on that point, it does seem that much of the feedback on the bill is about what detail sits in the overarching principles overseen by the ACCC, and what detail will be worked on by the regulator and industry as each of the initially 3 sector codes are developed. Are you able to give us some insight into the benefit of establishing the framework through these sector-specific codes and any insight into what the consultation process will be to set up those codes?
Certainly. So perhaps just at a high level, the legislation, as you've pointed out, sets out high-level principles and obligations. And the reason why the codes exist is to move from some of those high-level obligations into some of the more detailed areas that are much more appropriate to handle in subordinate legislation, because, as you can imagine, scams evolve and change quickly, and so it's necessary for us to have a capability that enables some sort of response to that in a timely way. So that's why you have the 2. And then in terms of the consultation process, I think what you would see is, in some ways, a mirroring of some of the consultation that we've already undertaken to date, where we'd make sure that there's public engagement and full engagement from all of the sectors that are involved. And so we would continue that on. And unless there's more that my colleague wanted to add to that.
No, that's right. We would anticipate that draft codes would be released for public consultation, giving not just industry but other interested stakeholders an opportunity to comment and consider what the obligations are. At the heart of that design element is that we can structure the principles that would apply broadly in the primary legislation, and as scams evolve and industries that are potentially subject to the scams prevention framework can be brought in over time, specific requirements appropriate for that industry and the function that it has in the scam life cycle can be created.
Senator Smith.
Thank you very much, Chair. On notice, can you provide me with the details of the consultation that you have undertaken with individual organisations, but also with industry associations since May 2022 to give effect to the bill that was introduced late last year? I'm particularly keen to understand the dates and the nature of the consultation and who was consulted with. When do you expect the scheme to be in full maturity?
So the timing really is a matter for government. The steps that are, but to give you an idea of, what does full maturity look like? So first of all, there would be a designation. So sectors would be designated. There are processes that are specified in the bill that talk about what the minister must do in order to bring that designation to life. There would be rules that would be developed as well as codes, so that they're probably the three main things. So it's a matter for government as to how quickly it would want to move on all of those things.
How quickly can the Treasury move on all of those things?
So I would say that Treasury responds to the needs of the government of the day. So I'm sure whatever the government was able to accommodate, we would do our best. But to give you a rough sense of timing, I think it's our expectation that we would be working on those things in 2025.
December 2025 or earlier than that?
So we'll be working on that throughout the year, and my understanding is that there'll be, again, it's a matter for government as to, what the specific timing is for any of those things.
Is the work of Treasury delayed because of the imposition of the caretaker period? If instructions have not been given to, if policy decisions have not been given to Treasury from the responsible minister?
So at this point in time, the major factor that would trigger the next piece of Treasury's work is the passage of the legislation. So I'm not anticipating that a caretaker period would be of concern.
That doesn't make sense. There will be an election this year.
Yeah. So what I'm saying is that in order for us to start the next piece of our work, the legislation, the passage of the legislation is necessary. And then if there was a caretaker period involved in that, I'm not sure that would actually add any particular delay to the work that we're doing.
But if the minister has not provided to you any instruction or any policy guidance on the matters that you outlined, then that will delay the development and finalisation of a scheme.
Well, only if the intent was for all of those materials to be prepared almost instantly after the passage of the legislation. So, but there's another scenario.
But the Treasury is not working to a time frame in terms of when it expects the scheme to be fully mature, or actually before maturity, before fully operational.
Well, to give you some indication, so the government provided funding for AFCA to be able to be in a position to handle complaints, and that funding was provided with a view that AFCA would be ready to handle those complaints in early 2026.
Early 2026, a year away. We're in early 2025.
That's correct.
Is the Treasury considering the presumption of compensation issue? You may have listened to the evidence of consumer groups a moment ago. They said to the committee that their understanding was that the Assistant Treasurer had asked the Treasury to formally consider the presumption of compensation matter.
So my understanding is that there were legislative amendments that were actually proposed by members, and in response to that, it's traditional that Treasury would be considering what the ramifications of those would be.
So Treasury is formally considering amendments to the bill at the moment.
So perhaps just to clarify, it's a typical practice that if any amendments are moved to any bill, Treasury would provide some sort of analysis in that context. As to whether we're doing it right at this very second, I can't, but I can confirm that, when we do get notice that there are amendments being proposed, it's natural for Treasury to consider what the implications of those might be.
Has Treasury been asked to formally consider any of the amendments proposed in submissions to this inquiry?
So I might need to take that on notice as to what you mean. Well, in regards to formal, like have we received a formal request? But
The amendments that are detailed, that are proposed in submissions to this inquiry, has the Treasury been asked to examine any of them?
Yes, I might just ask my colleague for further information.
As Mr Dixon said, we've been considering proposed amendments to the bill that members of Parliament have moved, and we have been reviewing submissions to this inquiry to consider what stakeholders are suggesting, with a view to being prepared for any requests that we may receive to provide advice on those things. That's what we would normally do as committees are considering matters, and so we have been working our way through those submissions to be across what stakeholders have been suggesting and thinking about how those various recommendations might fit with the bill.
When does the Treasury expect the draft codes to be released?
So timing of that's a matter for government, Senator.
And you've received no advice from government in terms of when it expects the draft codes to be released?
I'd have to take that on notice.
Thanks very much. Just turning to the matters of designation and the process, etc. Before designating a sector to be subject to the Scams Prevention Framework, what matters must the Minister consider?
So the Minister has to consider scam activity in the sector. So, for example, the Minister may identify that certain businesses or services experience high levels of scam activity. The Minister must consider the effectiveness of existing industry initiatives to address scams in the sector. For example, there may be existing initiatives in a sector seeking to protect against scams but do not appropriately address scam activity in that sector. The Minister must consider the interests of persons who would be consumers of regulated services for the sector if the Minister were to make the designation. For example, the designation may be appropriate if the Minister considers that consumers would be better protected against scams arising out of activity in the sector if it's subject to the Scams Prevention Framework rather than relying on existing frameworks. Minister must also consider the likely consequences, including benefits and risks to the public and to the business or services making up the sector if the Minister were to make the designation. And the Minister can consider any other factors that they believe is necessary to consider and may be relevant.
Just last question, Senator Smith, if you have one.
I'll put some on notice. Does Treasury stand by the $228 million estimate in the regulatory impact statement?
Yes.
In regards to the compliance cost estimates of the initiative?
Yes.
Have stakeholders challenged those estimates?
I might need to take that on notice. Or provided
advice? Sorry?
Might have to take that on notice.
Okay, thank you very much. Thank you, Chair.
Thank you, Senator Smith, and thank you to both of you for being available to the committee today. Answers to questions on notice are due COB the 31st of January. That concludes today's hearings. Thank you to all witnesses who appeared, to Hansard and Broadcasting for their assistance. The committee stands adjourned. Thank you.